challenge the constitutional validity of a government memorandum, which has overruled the judicial direction of this court. We challenged it. It went before the division bench, and the division bench was waiting for the judgment. The judgment came in our favor, and the division bench now has transferred it to the single bench. And there is an urgency. We don't want the other matters. We want a particular matter where the bias is challenged.
What is the issue?
The issue is whether the benefit of the merit has to be given to the members of the reserve. That's the issue. And there's a Supreme Court judgments also. And 2 forums we won. But what happened, the government now has started nullifying it. They had the audacity, and that we have challenged. So the division bench has sent it before the single bench. Since no order was given on the date, I pray that there is an urgency, because the government is the last stage is going ahead with promotion.
This is the reservation issue.
No, it's the merit issue, not the reserve, because when we go up, we don't want any reservation. There's a misconception. The merit was denied to us. Sabharwal's judgment was violated.
So it's connected with the equality forum what matters.
No, it is not, because equality.
Once they have recused, because we,
what I
we are apart.
Yes, I won't call upon your lordship to take up. At least lordship will fix, because it's a fixed matter of hearing. At a day be given, then we can always bring it to
the records are not before us.
At least after 22, I am saying.
We have it listed.
Yes. Because the urgency is that the government is going ahead with promotion, and 60 departments are now affected. There's a total chaos. The government is not.
There's already a direction of the honorable division bench.
Yeah, that is the thing.
You approach the registry. Approach the registry.
We brought it before the registry because the
when did you bring? This is 29/8 recent
Yes,
order. We are on holiday last 4 days. File an application. If it's not listed, we'll do something.
We'll move the rails.
Yes, there's a clear direction.
Yes. Oblige.
You correct. There is a direction.
I want to move a unlisted motion today, madam.
Urgency.
Urgency is there.
What your
Urgency is there. From tomorrow, the disciplinary procedure, that inquiry will be started. After having so-called notice, the document which they have mentioned, my lord, that was not furnished to me, my lord. So I could not file WS, my lord. But they are going the inquiry from tomorrow. So, my lord, tomorrow I may be allowed, my lord.
not to convince. We'll have it, but we don't find any mail. Have you filed or not?
Yeah, I filed. Lord, I have on 2/9 I have filed.
2 o'clock.
Obliged.
May it please, Your Lordship, with due consent from the other side, I would like to mention item number 6. And for the government, Your Lordship, here we have received the record, but I have to go to the record. So in between,
Taken the consent.
we have taken the consent.
A date will be given, my lord, on 14th of
Next Thursday, Your Lordship.
A prayer for adjournment has been made by Sri D. Bora, Learned State Council. As agreed by the parties list on 14th.
14th.
9.
May I please, ma'am? I think to mention item number 4, my lord.
4,
Consent of the other side. Can it be picked next week, my lord? I need it.
Tell us. Oh, this is a 12 matter, Mr. Pai.
My lord, this is regarding
Format was directed to produce the report. We have received the records in this particular, that also we have received on 3rd of September. Due to holiday, we could not.
Not adjourn like this. We'll have this on Tuesday next.
Tuesday. Very
Yes, but I also appear, my lord. Can it be, instead of Tuesday, can it be Thursday?
Thursday. We have some difficulty on Tuesday. That's Thursday. Some difficulty on Tuesday.
Too many matters, actually.
What is that?
All right, my lord, let it be there.
12 matter, that is why. Otherwise,
Let it be there. Let it be on.
adjourning, we're just accommodating all the council.
Yeah.
Uh,
Let it be on Tuesday.
do a prayer for adjournment has been made. Considering that this matter is of the year 2012 and is specially assigned to this bench under the column top of the list, a small accommodation is granted, directing listing of this case on Tuesday. It is 12/9.
May it please your lordship. Your lordship, I beg to mention for listing of a writ petition, my lord, for hearing. The matter was last listed on 24/6/2022, my lord.
For hearing, it was for hearing.
It was for hearing, my lord.
Case of which year?
Sir, my lord, 2018.
Okay, try it on Tuesday.
Obliged.
Lordship, I pray for listing of a writ petition, Lordship, on Monday, your Lordship. Lordship, I am for the respondent,
What case? Listing for what?
orders, Lord.
Orders, right?
Lordship, because whatever the petitioner wanted, Lordship, it has been allowed, Lordship. It has been, so the matter is almost infructuous, Lord.
Here for the respondent.
Yes, your Lord.
This is to come from the petitioner. Who is
Lordship,
for the petition?
Mr. K. Goswami, Lord.
Okay. We'll try one.
Lordship, I beg to mention for listing this matter for admission, Your Lordship. Matter relates to termination of service, contractual employment.
Petition. Next week when?
Next,
Case of which year?
2023 year.
Matter. Why are you mentioning a matter of petition?
On 18,
When was it last listed?
it was last listed on 2/8/23.
There are so many matters, but what's the urgency?
Actually, his service,
Don't make a mention like this. Mention is for matters which are urgent, not listed for a long period of time.
actually, in this
Sorry.
matter, Your Lordship,
No.
in spite of giving the stay order,
It's
Your
not the
Lordship,
objective. It come in the usual course to reprove the registry.
obliged.
May please your lordship, would you consent of the other side? I beg to mention item number 16 of the daily list, my lord.
15,
16, one,
one
my
six,
lord.
yes.
My lord, both the Finance and Taxation Council, Mr. B. Gogoi and Mr. P. Chaudhary are indisposed as on today, my lord. They are not well, my lord. Matter may be taken up with any other
14
day.
matter, 14 matter,
2014 matter, my lord.
it is submitted at the learned council for the petitioner,
Respondent, my lord. Finance and Taxation Department.
for standing council. Submitted as to be standing council,
Industry.
taxation department is unwell and therefore a prayer for adjournment. Considering that this matter is of the year 2014, comma, a short adjournment is granted, directing listing of is on Thursday next Thursday,
My lord, actually, on Thursday, my series of matters of tax are.
then Wednesday.
Ma-
It is 13.
My-
14 matter you have to give preference. We are not, there may be series of matters. 14 matters have been. Yes, madam.
May I please, your lordship? Lordship, I pray for listing of a stay vacating application for tomorrow, your lordship.
You have filed it.
Yes, lordship, the matter was last posted on 25/8/23. The writ petitioner took time, your lordship. So it
When did you
authorized,
file the IE?
no, we filed it long back, but it was last posted on
No,
25/8.
did they have they got adequate time for reply?
1 week time was given, your lordship.
No, from the date of filing. How much time has passed?
Lordship, we filed prior to 25/8. It was last posted on 25/8/23.
Understood. We are asking
On
from the
that day,
date
they
of,
took time,
from
your
the date of
lordship.
serving of the copy, have they got adequate time for filing objection?
Yes, your lordship. 1 week
Okay.
time was
When you
given.
want, when do you want?
Tomorrow, your lordship.
Yes, ma'am.
Lordship, in regard to item number 20, Lord.
20.
Yes,
Clearly.
Lordship. The TP case, your Lordship, I need some more time for Lordship.
Why are you wasting time? There's nothing here. On the prayer of MS R. Chaudhary and counsel for the petitioner. Matters is adjourned by a week. We listed on Friday next.
Lord.
Next Friday,
Lordship,
59
15/9, Lord.
for motion.
Obliged.
May I please your lordship. Lordship, I beg to mention a writ petition regarding non-payment of retirement benefit. It was last posted on 19th of June.
Okay, we'll have it next week. Give a date.
Obliged, sir.
This item number 3, ma'am. That matter perhaps became infectious. It was related to recovery of LTC, ma'am, from the month salary of the March 2012. The man has already retired in 2013.
Okay. Three A.K. Hussain, Learned Counsel for the petitioner has submitted that by flux of time, comma, there may not be any life further action. Full stop. BTC, anybody? BTC? Anybody in the court whose name can be recorded?
I'll inform them.
Also heard the R. Dhar, Learned State Council, and P. S. R. Rabha, Learned Standing Council. writ petition is according as in practice.
Definitely, your lordship. I beg to mention item number 2, my lord. Kindly pass over the matter for the day.
Item 2 is put 2012 matter, difficult.
My lord, I'm appearing on behalf of NJ Datta, sir. He could not locate the file for that reason, my lord. If possible, Monday, my lord.
Okay. From 12 to 30. Monday. Have you informed the other side, finance part?
Probably my senior NJ Datta, sir, has informed, my lord.
Probably will not do. Anyone from finance, Mr. Dhar? Dhar? Finance department, anybody? No, is he around? Some matter has been adjourned. Okay, we'll have it on Monday.
Obliged, my lord.
Monday. 11. Top of the. Okay. Yes.
So if item 1 has become infrastructure, if it was out of town promotion, the petitioner were not considered for promotion.
R. Islam.
Lordship.
R. Islam. Account. No life further. R. D. Bora. State Council.
For time being, my lord, it may be.
Same matter, sister.
Silchar, my lord.
We have, I think. We have heard this matter on the last occasion. Yes, where is where are the response? Mr. Chaudhary. SP Chaudhary. Motion matter.
Mushal matter.
We had granted some interim protection.
My lord, my lord.
The Vishwakarma, yes, instruction. Instruction. The Silchar matter, NIT.
My lord, can I, my senior is just coming back.
Yes. Your matter has been taken up, Mr. Chaudhary. You are coming leisurely.
No.
We are about to allow the instructions.
Some instruction I have received. Pursuant to that instruction, lordship, all the petitioners, they participated in the selection process. So with regard to their grievance that it should not continue, that cannot lie at this stage because of the fact that they are also the candidate in the selection process. And the next point is that,
Not convinced.
and the next point is that lordship on the last occasion, lordship has,
Hey, how do you overcome the division bench?
yes, lordship has directed that what has
You
happened.
consider, have a
Yes.
discussion with the ministry, consider, reject the cases, matter ends there.
Lordship, there was a communication with the MHRD, lordship.
Hmm.
As per that, I'm just reading that particular specific paragraph, lordship.
Now, what has happened? Tell us, don't read.
Yes, as desired by the Honorable Court, MHRD nominee and the NIT authorities considered together in the BOG meeting held on 1st of June 2013 and discussed the issue at length and noted the Honorable Supreme Court in the case of Umadevi such and such. In paragraph 19 of the said judgment, the Honorable Supreme Court has observed that court cannot impose any financial burden of such nature by insisting on regulation of or permanence in employment. BOG further decided to sympathetically consider the cause of the workers working in the institute has allowed them to continue on humanitarian ground, even though the present nature of service required by the institute is not fulfilled by them properly and their educational qualifications are not as per the recruitment rule.
Has this consideration been communicated to the petitioner?
Yes, lordship. They filed a contempt. With regard to these petitioners, previously they had approached before this honorable court with the same issue. There was another recruitment process, and this recruitment process, just to stay the recruitment process, they approached this honorable court.
No, we are not.
And-
See, Mr.
And
Chaudhary,
during that relevant
Mr.
period,
Chaudhary,
yes, Lord.
our concern is only on the part of the matter where there is a direction of the division bench requiring consideration of this case. I am asking you a very straightforward question. In terms of the division bench direction, where the case is considered and the such consideration, the outcome was communicated to them. That is all. If you have done so, you go ahead with the
Outcome, because there,
this communication which you have just read.
Yes.
Was it an exercise pursuant to the direction of the division bench?
yes, Lordship, in 2013.
When was the direction of division bench?
Uh,
Justice
Direction,
Justice Goyal, I think.
yes, the writ appeal,
14/5/2015.
512,
12,
512,
5/12/2012, Lordship.
512. It was
It
in
was of
13.
2013.
Oh, then you have considered.
Yes, Lord.
Has it been communicated?
Yes.
Where?
And BOG, and as per the directive,
Where is the communication?
Lordship,
Where is the communication? Do you have-
specific communication was not there, because
When-
there was no such representation on the part of the petitioners
No,
also.
no, you have to consider. How do they know about the consideration?
Lordship, at this point of time also, if the issue with regard to the regularization is pending, then in view of this particular decision of the BOG or the MHID, we can communicate the petitioners also.
Oh, you communicate.
Yes, we can communicate the petition.
You communicate.
But
them.
they are participating in the selection process also.
No,
Lord.
their participation will not be a prejudice. Cannot cause prejudice. There is a court direction.
All the petitioners, I can
If
understand
they,
that.
if they participate, if they get the job, matter ends there.
Yes.
If they do not get the job, you cannot prevent them from participating in the recruitment.
No, there is no such prevention law.
No,
We
no,
have, we have
that- those-
considered
that-
them, and
that
we have given the age
participation-
relaxation
that-
also.
That participation cannot be to the prejudice of certain directions of the division bench. If you say that you have already considered, you communicate them, put it on
Yes,
an
sir.
affidavit, will
Yes.
dismiss this. Okay,
I'll file a short affidavit and closing this
and
particular
but
thing.
before filing the affidavit, your decision needs to be communicated. In the affidavit, if you are putting across your communication in the court, which is not a communication, your decision without being communicated, that is not a decision. Unless your decision is communicated, they are not aware of it.
Here in this case, Lordship, there was no such representation also. Because
Was
the
was there any requirement of a representation?
communication is possible when there was some
Let us see let us test your argument in view of the division bench. Kindly come to page 46.
46.
Having regard to the above facts and see, here their writ petition was dismissed, isn't it? This
Yes.
is the appeal filed by them. Division bench did not accept their case, but while dismissing the appeal, what has been stated that having regard to the above facts and of the appellant have already served for more than 30 years and are still continuing in service, it will be in the interest of justice that the issue is considered again
Yes.
by the NIT as well as the Ministry of Human Resources as far as possible within 6 months from the date of receipt of the certified copy. There is no requirement of a representation.
Pending decision of the issue, the appellant may be allowed to continue.
Continue.
They were allowed to continue.
They have been allowed.
Yes.
Now, if the recruitment process, they are out, they are gone without a consideration. It appears that you have considered.
Yes.
Only thing is that you have not communicated to them. You communicate to them that you have considered. And if you have any other data or any other materials to show that they were also aware of such communication, such decision, you can also put across in the affidavit. We are only concerned whether they are aware of the which we have taken pursuant to the division. How much time?
Court date may be given, Lord. Today,
Heard PAR Bhaiya, learned counsel for the petitioner. Also heard SP Chaudhary, learned pending counsel,
yes, Lord, pending.
pending counsel, appearing for the NIT sector full stop. Para. This court by the order dated 1/9/2020 had direct the learned standing counsel to obtain instructions on the matter, and in the interim had directed that no steps be taken to fill up the post of junior and senior assistant, which are part of the advertisement dated 7/7/2020, without first considering the case of the petitioners for regularization of their service in terms of the direction dated 5/12/2012 passed by the Honorable Division Bench in WA 369 of 2008. Sri Chaudhary, the learned standing counsel, has submitted that part instructions have been received as per which, comma, no, as per which the petitioner have also participated in the present recruitment process. Full stop. He also submits that in the year 2013 itself, comma, a decision was taken on the, that 13 itself, comma, a consideration was made in terms of division bench judgment, direction. Full stop. However, comma, the learned standing council is not certain as to whether such decision was communicated to the petitioner. We have termed it this way. We have not said or not communicated or communicated or not said. Sarah, the Chaudhary according to this for some time to obtain instruction in this regard and also to file an affidavit putting the aforesaid fact on record.
Mal.
Sarah, please after 2 weeks.
And next week also, Lordship, because there is some urgency in the matter. So there's a recruitment process going on.
Next Friday,
14th, Lordship, Friday on difficulty.
Friday.
14th, Thursday.
Thursday, can you file it?
Yes, Lordship, I can file.
As agreed to by the party, it's not 14/9, by which time the affidavit will be filed. But when do you communicate?
That the entire instruction I will obtain and I will
When
submit.
do you communicate? If you don't communicate, we may not, on affidavit, we may not accept. Take 2 weeks time, nothing is going to happen. Or not 2 weeks, we fix on a date on the next week, immediately on the next. This on, we'll have it on 28th or 18th. 28th, 20,
20.
20, on 20, yeah? Sarah, interim order passed earlier.
Mal.
To continue till the next set of.
Obliged.
29 will try for disclosure.
28th of September.
Yes, 29.
29.
29. 29. This,
Obliged. Hello.
what is it?
May I please, your lordship, my lord, this matter is regarding the dismissal from service on the ground of disaster, my lord. And
On the
myself,
ground
I have joined
On the ground of
disaster. Means
disaster.
he was
Disaster.
DESERT, disaster,
Deserter.
deserter.
Deserter, you become disaster. You're making disaster of everything.
Deserter.
Deserter. Yes. What is that? You deserted.
Yes.
And called the
I was
disaster.
working as a constable general duty. I have joined in the year
Yes,
2000.
affidavit file.
Yes, ma'am.
You want to go for hearing?
Yes, ma'am.
Go for final hearing?
Yes, final hearing.
Yes.
Today for final hearing.
Yes.
Yes. No, I have joined. I thought that lordship is going to pick another day.
No, if you are not ready, then matter is different. If you are ready, why not?
No, yes, I'm
Yes, tell us. Who are you?
lordship.
Who is
I
the
have
petitioner? Who is the petitioner? He is the what? Constable.
yes, he was working as a constable general duty. He have joined in the year 18 January 2014, your lordship.
18 January.
Yes.
February,
Eight-
my lord.
18
February.
February.
2014. Thereafter, he was transferred
Joined,
to
you joined. Where?
Indo
Indian Tibetan.
Indian Indo-Tibetan Border Police Force.
ITBP.
Yeah.
ITBP 4.
Yes.
Okay.
Your lordship, the impugned order is in affidavit in opposition filed by the respondent, your lordship. The affidavit in opposition is
Now tell us the facts, then we'll go to the appeal order.
yes.
Then what happened?
Thereafter, your lordship, he was sanctioned earned leave with reference to 26/11/2019 to 14/1/2020, Your Lordship.
Hmm?
Your Lordship may kindly,
Earned leave was from when?
Your Lordship may kindly take up the impugn order, affidavit of position. There it is very clear. So that my petition having some typical error. Your Lordship.
Page?
That is, Your Lordship, page number 30, annexure 7. Page 30,
number-
affidavit of position.
Yes.
Annexure 7, Your Lordship.
Hmm.
It is very clear.
Please read.
No, on leave with reference to the second line, Your Lordship.
Yes, yes.
26/11/2019 to 14/1/2020. And in continuation of this leave, 30 days on leave was extended.
Yes. Yes.
Mm.
Then
Then thereafter, Your Lordship, he myself he wants to join Lordship, while he was on leave, he fell sick and he was diagnosed as anxiety disorder, Your Lordship.
okay.
He was diagnosed as anxiety. And Your Lordship, Your Lordship may kindly turn to my petition, Your Lordship.
Hmm.
That is page number 11, Your Lordship,
Hmm.
annexure A1. It is to whom it may concern by the concerned doctor from Nirim.
Hmm.
The second para, Your Lordship. He was diagnosed as a anxiety disorder, a chronic neurotic mental illness. And he was asked to take medical care from 8/2/2020 to up to 5/6/2021, Your Lordship.
Not asked. He was under my care.
Under.
Now, where is he advised to take bed rest or not to go for work?
No, he was mentally not sound, Your Lordship.
Where is the certificate?
It's just certificate is not there, but under this, he was medically treatment was going on.
Hmm.
And I have,
I have just. Then what happened?
and thereafter, Your Lordship, my annexure 2, Your Lordship, page number 23.
Yes.
Annexure to A2, page number 23. I have made a request for allowing to join to normal duty, Your Lordship.
When was it?
That is on this letter was given on 17 July 2021.
Yes. What happened thereafter?
Thereafter, my lord, I have booked the ticket for joining, but on the on the day of departure, I fell sick again. That Your Lordship, it is reflected in page number 30 of my repetition. Page number 30. This is the bus ticket. Journey is on 15/2/2020, Your Lordship. Departure journey from Imphal to Guwahati. Last page, Your Lordship.
So how is it possible? Your application is dated for 17/7/2021. Isn't it?
Yeah.
17/7/2021. Case 23. Connector A2 of your petition. Got the date?
Yes, yes, 17 July
2021. And your bus ticket is the 15/2/2020.
No, that is, this incident is prior to the, my application for request. Because of that, my absence was extended. Which I have stated in my petition also.
Okay, then. Then what happened?
Then Your Lordship, then thereafter, annexure to, one minute. Your Lordship, shall I, Your Lordship can, this, I will go through nicely. Another
What
that
is
can,
this interesting?
Yes.
We asked you, are you prepared? You said you are prepared. You wasted 15 minutes of work.
Your Lordship, I'll continue, Lord. I'll continue.
You're not prepared, you should say at the beginning.
I was trying it.
And what has happened thereafter?
Yes.
You're not allowed to join.
Yes, I was not allowed to join, and the impugn order stands.
Page 60, page
The affidavit of opposition, Your Lordship, page 30, Your Lordship. Annexure 7. Only my submission is that this is the post of police force constable border area. I deserve this because I have not informed to the competent authority it was absent more than 3-4 months without any knowledge, without any permission. But is this because job is concerned, is timely discipline and
there was a court,
punctuality.
there was a court inquiry also. Did you participate in the court inquiry?
No, I have no idea. I was not informed. The contention of the respondent is that I was informed, but I have no knowledge about it. And at that time, the treatment was on also, Your Lordship.
From 13 to 2020, you came back on 17/7/2021. Almost 1 year, 5 months.
Yes, almost once. 1 year.
1 year, 5 months. What is your explanation?
Yes, 6 months.
1 year, 6 months, 5 months. 5 months, around 1 year plus, 1 year, few
What is
months.
your explanation?
My explanation is that's what I deserve for this punishment, Your Lordship. But only thing is that Your Lordship may direct, only last chance may be granted to examine my health, and because it's my career, because I have served more than 8 years in the border area
No,
and
you have,
constable and,
we cannot,
the treatment.
we cannot enter into the marriage. We can only examine the decision making process. The charge against you is, and you are admitting the charge from almost 1.5 years.
Yes,
You have
yes.
not joined. There is no explanation. Medical certificate says that you are not well, and much before at page 11. There is no explanation.
No, this I deserve. I'm telling I deserve this.
Then
But
what-
only thing is that the authority may consider
Have you filed an appeal against this?
appeal, because appeal was barred 90 days. That thing was later on, because at that moment when this impugn order was passed, it was not communicated to me. When I come to know, it was passed.
And you have filed,
Appeal, it
you
is
have filed this on 1st of February 2022.
90 days passed.
And the order is of 27/4/2020. Even you have come to the report after 2 years. We may not find fault with, since it's a matter of your removal from service. But unless you can show that there has been violation of the procedure, yes, did you hold an inquiry?
I have explained in details, my lord, in para 2, my lord.
Of your affidavit?
Para 2, my lord, of my affidavit.
Yes.
And this is the post of which required to maintain the discipline, my lord.
Those parts we are not having any problem. The post discipline code needs to be there, but we are only concerned, did you follow the procedure?
My lord, he was sanctioned 50 days leave, my lord. From 26/11/2019 to 14/1/2020, my lord.
Yes.
Thereafter, we have received an application from the petitioner that seeking extension, my lord.
Yes.
30 days we have extended.
Yes.
From 15/1/2020 to 13/2/2020.
Correct.
My lord, thereafter he has not come and reported to his duty. My lord, thereafter we have issued a memorandum to 18/2/2020 and 26/2/2020.
1 second.
Mem
1 second. When did you issue memorandum?
Memorandum 18, first one is 18/2/2020.
18 to
2020. Page, my lord, 51. 51 regular page, my lord. 51.
51.
Yes. Yes, my lord.
18-2.
Huh?
18-2.
18/2, my lord.
Yes.
You were saying office memorandum, my lord.
Yes.
You were sanctioned 80 plus 1 days earned leave with effect from 26/11/2019 to 13/2/2020, including forward journey time on 15/11/19. My lord. After expiry of leave, you required to report at battalion hours headquarters on 13/2/2020 afternoon. But you have not reported at battalion headquarters so far. You are absenting yourself without any permission of the competent authority, which is punishable offence under Section 21A of ITBP Act 1992. Therefore, you are directed to report at battalion headquarters along with all relevant related documents within 2 days of receipt of this memorandum. Otherwise, disciplinary action will be taken against you. And thereafter, my lord, the another to 26/2/2020 memorandum at page 53, my lord.
Was it received by him?
It was issued to by registered post, my lord.
Where have you stayed?
My lord,
Where have you stayed?
53, my lord. Page.
Where have you stated that it was sent by registered, issued by registered post?
At
Your paragraph C.
2D, my lord. 2D.
2C.
2D. At page 4, my lord, regular 34, my lord.
Now, where have you stated that it was sent by registered post?
And duty, but individual, you know.
How was this? How were these communications issued?
This is not explained, my lord, how this has been started.
You come to the communication, you have just referred, is 51 and 53.
53 and
51 also, 51 and
50.
come,
53,
come to 51 for a moment, copy 2.
copy to Decoy 33 Battalion, ITB,
To inform the
to
individual
inform the
through phone.
individual through
Phone.
phone.
Was it done?
Yes, my lord.
Where have you
No,
seen
no,
it?
no. It is not clear, my lord.
No, this document that from the documents it appears that you take adequate steps to inform him. But was it done? You have not made any statement in the affidavit that pursuant to this direction he was also informed to telephone.
And 55 also, my lord. 55 for Gaumbuda, my lord.
Was it done or not?
Yes, my lord. We have, to my information, it is done, my lord.
Your information will not to Mr. Dutta. You have to state it in the affidavit. You are a counsel.
My lord, now I would like to submit the document 55, my lord.
Both the documents, the 3 documents, the contents as well as copy mark appears to be in order because one copy you have also marked the wife to send her husband to the headquarters as soon as.
Yeah.
Now whether it was actually sent or
Now 55 also, my lord. 55 also to the senior commanding of police, my lord.
we've seen this. Now, was it actually sent or telephonic information given or not? You have not stated in the affidavit.
But here's the obligation to report the authority.
Understood. You have not reported. Can you just hold him to be a deserter? You have to follow a procedure, isn't it? You try to
Yes.
follow the procedure. You have issued notice. But issuing notice, you have to make a statement that it was actually issued by registered post or any other means. In the affidavit, you are silent.
But,
You have not even.
I will send it to senior commanding of police of that area.
Where have you stated?
My lord, at page 55, my lord.
Yes. Copy 2.
Such and such, please refer this office memorandum 7th dated such and such, which were directed to report at battalion headquarters immediately along with the documents related to your overstay for leave, and you have not reported at battalion headquarters so far, which is punishable such and such. There are you request back to such and such. My lord, this is a copy to office in charge, Saru Chandrapur police station for necessary action. And Srimati, this is wife, my lord, and the Gaumbuda village head, and Laleng which intend to apprise individual to report of this and duty as soon as possible, otherwise arrest warrant will be issued. That is
You've got the record. Sir Doctor, got the record.
not a record, my lord, still record, not
Your affidavit is lacking in many aspects. You have simply sent, stated the affidavit that these are the communications which were sent to the petition. You have not stated what's the mode of issuance, number 1. Number 2, you have not even made a statement that those were actually received by the petition. And in spite of such receipt, he did not make any, it did not come. You have stated that you sent copies to the police station, to the wife, to the Gaunpura. Why those communications received? What was the mode of sending? If it was completely silent, one statement would have made the difference that he was served with this, he received this, but in spite of that, he has not come forward.
my lord, another aspect is that the application Dated to 24/4/2020, I have received my lord,
Where,
from the petitioner
where?
at
Page
Annex 8A, page 64, my
64. Just a minute,
84, my.
just a minute.
Page
Just a minute, please.
64, 64.
1 minute. Sixty-four.
64, my regular.
Yes.
Regular print, 64. This is the latest application from the petitioner, my lord. Dated 24/4/2020, which we have received, my lord.
Yes.
A late leave later request. Subject, my lord, to Commandant 33 Battalion, TBP, Guwahati, Game Village. It is very unfortunate to state that recently I lost my father due to severe illness, expired. Therefore, I could not come back at the time even of I want. Since I have to take a responsibility regarding my family situation, I find a delay the given date till date. Then I was expecting to come back as early as possible, but due to the widespread of pandemic COVID-19, government ordered 21 days lockdown, and there was suspension of transport traveling between states against what detained me. After the pandemic issue had been solved, lockdown had been stopped, I would like to return to my original unit post. Therefore, I kindly requesting you to acknowledge my current situation. I will remain grateful. Sir. In response to that or that application, my lord, we have also sent a office memorandum at page 66, my lord.
Yes.
Page 66.
Yes, please.
Calling him back, my lord. Office memorandum 25/2020, my lord. Please refer to your application dated 24/20, which you have informed about date of your father and not reporting on duty in battalion, keeping in view of lockdown due to coronavirus pandemic. In the above context, it is intimated that you were sanctioned 50 plus 20 days earned leave with effect from such and such, and in continuation to this leave, 30 days earned leave extended with effect from such and such. You are unnecessarily absenting yourself from leave rather than reporting on duty after expiry of leave. Final proceeding has initiated for your dismissal from service under the ITBP Act rule due to absenting himself from leave without prior permission of the competent authority. As far as you referred non-flying of transportation due to lockdown in this regard, it is intimated that lockdown started with effect from 25/3/2020, whereas you required to report on duty with effect from 13/2/2020 afternoon. Besides, you have mentioned date of your father for which date and death certificate not submitted as approved. On the basis of your application, it seems that you are trying to mislead administration, which is not expected from the disciplinary post or its personnel. Therefore, you are again directed to ensure to report on duty rather than submitting unnecessary problem communication. In case of delay, final proceeding from your dismissal from service uh, which is in process due to absenting himself from leave without prior permission of the competent authority will be finalized, for which you and yourself will be held full liable. This is the letter, my lord. And thereafter, so-called notice was issued, my lord, at page 68, my lord. This is so-called notice.
Yes.
This is so-called notice was issued, my lord.
So-called notice is dated what? 6/5.
68, my lord, page 65, 2020.
Yes.
So-called notice was issued. But after, my lord, it is the later next page, my lord, 69 page number.
When opportunity-
To Deputy Director General, Directorate of Advertising and Virtual Publishing. It is for publication in the newspaper, my
Where?
at page 69. This is the letter from the Commandant to the Deputy Director General, Directorate of Advertising and Virtual Publishing. And
Yes.
69 page. This is the letter from the Commandant.
Where is the publication?
Publication is a notice at page 71, my lord. Impal English, Manipur, Associated Commandant. This is the letter. Asian Media Executive for DG DABP. It is from him, my lord. It is the letter from the Directorate of Advertising and Virtual Publishing, my lord. This is letter issued to the Commandant, my lord. With regard to the publication. In aspect of petitioner, in subject it is mentioned.
Okay.
With the publication and thereafter dismissal order has been passed, my lord.
Page
Page 72.
72.
72. This is a translated copy, original copy as a English language, my lord, 74 is it. Here, my lord, the authority regularized 114 days as EOL. is sent by registered post, received at 76 miles.
Eight.
76 receipt. This is the receipt by registered post. This is 76.
Yes.
So, my lord, it is the dismissal order page 73. It is stated that as per provision contained in rule 4, my lord, 73 page.
Yes.
4, my lord. Therefore, as per provision contained in rule 17, rule 20 of ITBP, rule 1994, the state number such and such Simingthang Aupik 33 Battalion ITBP is hereby dismissed from service, dismissal from service with effect from 6/6/2020. The period of state individual with effect from 14/2/2020 to 6/6/2020, total 114 days, is regularized as EOL for all purposes, and he is struck off from the strength of 33 Battalion ITBP with effect from 6/6/2020. That is the 6/6/2020 effect.
Yes.
Therefore, my lord, after 1 and 6 months, 1 year, 6 months, my lord, is submitted an application before the commandant at page 77, my lord.
77,
my lord. Request for allowing to return and join to normal duty thereof. This is the type copy, my lord. Original copy 78 page. Original copy. We start.
Yes, we have read this.
And thereafter, my lord, we have given a reply to him in response to that application. We have given a reply at 79 page, not 79, my. Subject regarding application for rejoining of number such and such is topic dismissed from service from 33 Battalion. My lord, at para 3, my lord, bottom, my lord. You have requested for joining of service after elapse of approximate 1 year, 1 month.
Yes.
You have requested for rejoining of service after elapse of approximate 1 year, 1 month, 9 days from the date of dismissal from the service, whereas as per rule 28 of ITPP rule 1994 prescribed period for appeal is 90 days from the date of dismissal. But as per rule, after elapse of prescribed period, you cannot be allowed to rejoin.
You're reading which page? 79.
79 page now.
Yes.
regarding joining in response to that letter, my lord, at keep para 3 months. That is that application is submitted after 1 year. They already the limitation of appeal before the higher authority already left. This is the my case. My lord is being at the discipline, working in a discipline post. My lord, he also have something he required to inform the authority about his difficulty. But but he is silent, cheating without informing the authority, for which they have to suffer a loss, my lord. Now, he, at his own will, my lord, he is coming after 1 and 6 months.
Okay, anything else?
My lord, in my additional,
Mr. Dutta, anything else? No.
Huh?
Think,
my lord, in my rejoinder, my lord, that is para number 3, my lord. In my rejoinder, page number 3, your lordship. Page number 3, para number 3, your lordship. I have stated, your lordship, that
page,
OM dated 18/2/2020.
where, para 3.
Para 3, your lordship.
Yes.
Your lordship, OM dated 18/2/2020, 26/2/2020, 4/3/2020, and 16/3/2020. With 16/3/2020, it is stated that it is addressed to my wife. It was not delivered, your lordship. At the same time, your lordship, the police also has not given any information, your lordship. Police also have. Only thing is that I have earlier also I have said, your lordship, I have submitted that I deserve this dismissal, but only your lordship may kindly consider that at this last chance may be granted. If I am medically all right, medically sound, then the authority may consider my resuming my post, because it was, I have already served more than 8 years, your lordship. I have joined in
You have been
2014.
dismissed from service on the ground of being a deserter. Now, to interfere with the ground, with the dismissal order, which is on that ground, you have to make out a case that you did not desert before.
Yeah.
The facts and circumstances make it clear that you did not have any intention to go back and join. There were a number of communications. You have stated that you have not received. There were newspaper reports also in 3 newspapers. You have not received.
Yes, your
You
lordship.
did not go back.
I was not medically or not all right. I was under treatment.
You don't have a you don't have a medical certificate which conclusively says that you are not supposed to go for duty, you need to be under bed rest. That is not there.
Yes, correct. And lordship, that bus ticket I have changed. I have
Bus ticket, yes, you had the intention.
I have intention to join, but
Thereafter-
I have to come back again because of my.
Did you write to them? Time and again, yes, this is my position. I am not being able to join. Just hold back. You did not.
That is the mistake, and that is I have admitted, your lordship.
You
I
have
have
not-
admitted that.
You are oblivious of what is happening in the office. Nobody, you are not bothered at all. Heard. Three. And when it comes for the also heard. Three. A.K. Datta. And KSDI. That is this is appearing for all the respondents. By means of this petition, the petitioner has to tell an order dated 6/6/2020, by which the petitioner has been dismissed from service on the ground of being a deserter. Full stop. Para. The fact as predicted is that the petition was appointed as a constable within bracket GD in the ITBP4 in the year 2014. Full stop. While being posted at Guwahati in the year 2019, in the year 2020, he had taken earned leave on from 26/11/2019 to 14/1/2020. However, due to certain medical conditions, the said leave was extended from 15/1/2020 to 13/2/2020, and such extension was also permitted by the office. Full stop. Pursuing the learned counsel for the petitioner has submitted that the petitioner was unwell and was suffering from anxiety disorder, and in this connection, he has referred to a medical certificate dated 5/6/2021. Full stop. As per the said certificate, the petitioner was under the care of the concerned doctor from 18/2/2020 to 5/6/2021. Full stop. To show the bona fide of the petition, proceedings has also referred to the bus ticket dated 15/2/2020, by which on which date he had intended to come back to Guwahati to rejoin his post. Full stop. However, might submit that the petitioner fell ill and therefore he could not rejoin. Full stop. Sarah, receiving the learned counsel for the petition has submitted that at no point of time he had received any communication from the office directing him to rejoin the post, and in this connection, he has referred to paragraph 3 of the affidavit in reply dated 21/7/2023. Full stop. It is according to submission that the impugned order of be set aside and a direction be granted for a fresh consideration of the case of the petition and to allow him to rejoin his service. It is emphasized that the petitioner had served or was serving continuous since 2014 without any stigma, without any blemish. So, per contract, the doctor, the anesthesiologist has submitted that in a matter concerning a disciplinary proceeding, unless a case of latent illegality or irregularity is made out, this court may not interfere with that decision. He submits that in the instant case, all procedural safeguards were afforded to the petitioner, and in fact, not only notices were issued to the petitioner repeatedly, there were paper publications also directing him to rejoin the service, in spite of which the petitioner chose not to come back to the office. The doctor has referred to the communication dated 18 to 2020, 26 to 2020, and 4/3/2020. He established that not only notices were issued to petitioner, but copies of the same were also marked to the office to his wife, as well as the Gaunpura and officer in charge of the concerned PS to intimate the petitioner about his rejoin. Though the petitioner in his rejoinder affidavit has denied receipt of any such office memoranda, the petitioner has himself issued a letter dated 24/4/2020 requesting to allow him to rejoin. However, it appears that in spite of such letter, the petitioner did not rejoin, and in this regard, another of his memorandum was issued on 2/5/2020 directing the petitioner to rejoin. In the meantime, an order dated 27/4/2020 was passed after a court inquiry holding the petitioner to be a deserter. The doctor submits that in spite of such declaration, another so-called notice was issued on 6/5/2020 directing the petitioner to report for duty. On the same date, a communication was issued to the director of advertisement and visual publicity, New Delhi, for paper publication of the notice. It appears from the communication dated 26/6/2020, which was a reply from State Directorate, that notices were published in 3 newspapers having circulation at the place of residence of the petition. Full stop. The petitioner not coming forward, not having coming forward, ultimately, on 6/6/2020, the impugned order was passed whereby the petitioner was dismissed from service. Full stop. The state order has also regularized 114 days, which was out of leave. The doctor submits that after about a year and a half, the petitioner had filed an application dated 17/7/2021 to allow him to rejoin, which was replied by the department. Both replied by the department in the negative, as in the meantime, given the period prescribed for preferring an appeal was over. The doctor also points out that the instant writ petition was also filed after a considerable delay on 1/2/2020, and therefore the petition is not entitled to any relief. A court in exercise of powers conferred by Article 220 of the Constitution of India is mainly concerned with the decision process rather than the decision itself. In the instant case, it appears that the initial leave, which was from 26/11/2019 to 14/1/2020, was extended from 15/1/2020 to 13/2/2020. Full stop. In the writ petition, the petitioner has annexed a medical certificate dated 5/6/2021, whereby the period of treatment has been stated as 18/2/2020 to 5/6/2021. Full stop. Apart from the fact that the ailment has been diagnosed as anxiety disorder, there is no advice to remain in bed rest or not to attend duties. Full stop. It is also not the case of the petitioner that he had ever intimated the office about such ailment. Full stop. This court has also noticed that though the petitioner in his rejoinder has denied receipt of any office memoranda requiring him to rejoin the office, rejoin his duties, the department had also made paper publication.
Yes,
In spite of which there was no action of the petition. There was no move on the petition to rejoin his duties. Full stop. The aforesaid conduct of the petition makes it clear that he had the intention to desert the force, and therefore this court is not in a position to find any fault with the finding arrived by the order dated 27/4/2020, declaring the petition to be a desert. This court has also has even noticed that even after such declaration, comma, a further so-called notice was issued on 6/5/2020, whereby the petitioner was directed to rejoin his duties, and the state respect was also given published in the newspaper through the Directorate of Advertisement and Visual Publicity. The conduct of the petitioner in filing an application after almost 1.5 years after such dismissal also shows the lack of due diligence on the part of the petitioner. Under those facts and circumstances, this court is of the opinion that the petitioner was afforded proper and adequate safeguard to defend his case and also to rejoin his duties, which he failed to do. And therefore, this court is of the opinion that no case for interference is made out. Petition accordingly dismissed. Seven, what is this?
Okay, your lordship. Lordship, matter relates to appointment of peon in the Punjab National Bank, lordship. Initially, lordship, the petitioner applied for the post of peon and she was selected and appointment.
Ganguly, you're for the bank.
Lordship.
Affidavit filed.
Affidavit filed.
I
placed this short question in call.
Take for disposal.
Yes, lordship. Lordship.
Yes.
Lordship, the advertisement was for the post of peon in the Punjab National Bank, lordship.
Advertisement was there.
Advertisement was there, lordship. Advertisement is at page 15 of the writ petition, lordship. When petitioner applied, lordship,
Just a advertisement dated
advertisement dated, lordship, 3/2/2022
for peon.
for the post of peon, lord.
How many? Three numbers.
One lordship.
One peon. One post.
No, ST, unreserved 5, lordship.
You belong to unreserved.
Lordship, yes, I belong.
The advertisement is dated 1/2/01, 1st of February 2020.
Not third.
Not third. Because it was published in the Sentinel paper on 1st of February 2022.
Okay, doesn't matter. First of February.
Lordship.
1, 2. You belong to unreserved category.
Lordship,
You belong
unreserved.
to how many posts? 3 posts.
Unreserved 5 post, lordship.
So
Page 15 of the writ petition,
5 posts.
lordship.
Yes.
Lordship, in the advertisement, lordship, clause 5, lordship may come to page 15,
1/5.
1/5.
Yes.
This is the lordship main issue here. Clause 5 says eligibility. Eligible education qualification and age on 1/1/22. It is given below, lordship.
the tabular, in the tabular form, Lordship.
Yes.
On age on 1/1/22 and educational qualification on 1/1/22 is said to be, Lordship. It should be minimum age should be 18 years, maximum should be 24 years. There is nothing wrong with the Lordship petitioner. Then comes the main dispute comes in the qualification, Lordship.
Yes.
In the qualification, it is written that minimum and maximum pass in 12th standard or its equivalent with basic with reading and writing knowledge of English. In the bracket, it's written, Lordship, the candidates having completed higher qualification, that is graduate and above, are not eligible.
Yes.
Here, Lordship, as on in terms of this eligibility criteria, as on 1/1/2022, she was a higher secondary pass. She was a class 12 pass.
On
1/1/22, as reflected in the advertisement.
Yes.
Initially, Lordship, she participated and she was appointment letter was also issued to her, Lordship. The appointment letter is in page number 16. 16. Next page, Lordship.
You were appointed.
Appointment letter was issued, not appointment.
25/3.
Lordship, 25/3/22 and XRP.
Yes.
Then, Lordship, the impugned letter was issued at page 22 and XRC.
Yes.
May I read, Lordship? It's to the petitioner, Lordship. Reference, your candidature for the post of peon has been rejected. Madam, with reference to your application dated 12/2/2022 for the post of peon, it is to inform you that the competent authority of Guwahati University has confirmed that, as per their record, you have cleared BA final examination semester so and so in the year 2021.
You passed BA final.
According to their rejection letter, I passed their final examination in terms of the Guwahati University's information given to the bank that I passed in 2021. Later on, Lordship, the bank has, Lordship, agreed that she was not a graduate in 2021. In their affidavit, they have admitted, Lordship. They have admitted that I became a graduate on the date of 15/2/2022. That was the last date of submission of the form. In their affidavit, they have categorically stated that.
You became graduate when?
15/2/2022. That is the last date of submission of the form for the post of peon, Lordship. So my case is, Lordship, as on 1/1/2022, I was not a graduate, and my case has been wrongly, Lordship. I have been wrongly rejected. This is the mindful case. And their affidavit, Lordship, may be perused, Lordship. In their affidavit, they have admitted that I qualified it because subsequently the Guwahati University clarified that I was a graduate in 2022 only.
Yes. When was the last date of the admission of the advertisement?
Last date of the admission, they have brought it in the by way of filing an additional affidavit, because it was not to the knowledge of the petitioner, Lordship.
So where is the complete advertisement?
Advertisement in the additional affidavit filed by the bank, Lordship, at page 48.
Page 48, I have annexed the type copy.
Where is the type copy?
Type copy starts at page 45.
Last date,
The last date, my lord, lordship will find at page 46. my lord.
when did you file affidavit? 29.
So initially we filed an affidavit in opposition, that was, my lord,
No, no,
not
that
the-
will come.
yeah, that was not.
Where
eligible.
is the last date? Is
Column number 10, my lord, last date of application,
Yes, yes.
46, page 46. Last date for receipt, my lord, 15 to 2022 up to 5 p.m. Column number 10. Also mentioned in column number 11.
okay. Okay.
Since advertisement categorically stated that as on 1/1/2022, I should not be a graduate. So I was not a graduate on 1/1/22. Lordship, I was graduate on 15/2/22, that is on the last date of submission of the form. So Lordship, the rejection
15
has,
to you became a graduate.
Lordship,
As on so and so, that was age, I think.
Lordship, no, it's written,
Age.
educational qualification and
Education
age.
qualification has got nothing to do with the date.
Lordship.
Education qualification has got nothing to do with the date.
Then Lordship, I was a graduate on the last date of submission.
It's a difficult third case for her.
Look, actually, what has happened is that initially the confusion was because of the date of the grade sheet. That I must say. But
No, that you have clarified.
that we have clarified.
Now we have come undisputed petition.
Yeah.
That on 15/2/2022, which was the last day.
Last.
He was declared to be a graduate.
On that very date.
Now,
On that very.
on a very,
But
But it goes both ways, my lord. Yes. If I may say so, we have nothing against the petition.
no, understood.
He has qualified on.
See,
his merit, we have nothing
we there, it's an established law that overqualification is a bar and has been settled by the
Lord.
court. It's a valid.
And my lord,
Bar.
the precise
in-
idea is
here-
is to protect those candidates who are only 10th and 12th qualified, that
Understood.
they may have access to a certain category of jobs.
No, there are other conditions, other considerations. A higher qualified candidate
Lord.
may not have the same manner of enthusiasm to work in a lower post, number one.
Yeah.
Number two, the moment a vacancy arises for which a higher qualified candidate is eligible,
Yeah.
he or she will jump to that.
Yes.
Another recruitment process.
Yeah.
These are basically the two
Lord,
considerations.
Lord.
So
And-
courts have held that it's the valid, not
Yeah.
discriminatory, it's not potent violation.
And your lordship.
But here is a very,
Lordship, may I, Lordship, one, and she submitted her form on 12/2/22.
She submitted.
On
Evidently,
12 to
on 12/2 she submitted, but
Submitted.
the last date was,
Was 15.
goes without saying, but the last date was 15/2.
Lordship.
And fortunately or unfortunately for her, on the very date, my lord, she cleared her last paper, she was declared as a grade. So she became overqualified. Now,
one
my
of
lord,
the rare cases perhaps when a person would be dissatisfied
dissatisfied with the honor.
with the declaration of result.
Well, actually, what will happen now is that, let us say, my
It
lord,
should have failed, then should have been
she
happy.
should have felt, she would have been happy at them. Now, now the moment she joins, what happens is that the candidate below her may also come with with another litigation saying that look at an overqualified candidate has got.
No, that,
My lord,
that is not
and
correct.
we have no
That-
favorites, my lord.
that is not.
We have no favorites in the matter. We would be very happy to give her also, but the fact of the matter is last date was 15/2. She became overqualified, and our own advertisement says that consideration of marks of 10th and 12th. And repeatedly, only 3 times in the advertisement, it has been said that anybody who has possesses graduate and above will be.
No, see, pursuing a graduation degree and possessing a graduation degree, these are two different things.
No, the advertisement
No.
says, my lord, those who are graduates.
No.
No, the advertisement says, no, those who are graduates are not
That is it.
eligible.
That is what I'm
Yeah.
trying to explain.
So as on the date of application, yes, she was.
Pursuing a graduation course and possessing a graduation degree are different.
Lord.
So one may pursue a graduation course, he will not be a graduate.
No.
First year, second year, even if it's third year, he does not get it for the exam,
No.
he'll still be treated as a higher secondary pass.
Yes.
He cannot say, no, I appeared for the.
No, yes. No. The idea is, my lord, that as on the last date of submission of application, my lord, she became overqualified. That is the whole issue. Now it may go either way, Malad. But the fact remains that there are other candidates also down below her who are Malad, not there.
You had held this selection on the basis of merit.
Yes.
What
the
what
merit
was
based.
the, you had written examination?
No, the advertisement does not talk about written.
Election criteria, page, column 6, Lordship.
Yes.
Yes, Malad. Yes, column 6. Percentage of marks Malad, obtained in 10th class or equivalent, 40%. Percentage of marks equivalent obtained in 12th. That is what. And in the third Malad, any qualification other than the higher above two not to be taken into account. Specifically mentioned, Malad, graduate candidates are not eligible. That's it. 40% from 10, 60% from 12.
Means
So,
Lordship, appointment order was also issued. One post has been directed to be kept vacant for the interim order is there.
Very thin line.
in line, not. But write down from Lordship are aware, Malad, right from Rekha Chaturvedi's case, Ashok Sharma, all those line of judgments are there. That last date of submission of
No, no,
application.
those are
Yes, that is that.
no, last date of submission. You need qualified.
No, last date of submission of the application.
That is, you need to be qualified.
And on the same day,
Here is a case where you are
Malad, in
disqualified.
her case, the astronomical configuration was such that both conjunctions happened on same.
No, those cases may not have a direct relevance because those days that if you acquire some qualification
After the
after the last date,
after
those will not be taken into.
So the cutoff mark has to be Malad, that
Cutoff is now cutoff is for disqualification.
in those cases also it will be disqualification only because if
No.
for instance
Those cases are not qualification. Those cases are for qualification attained after the cutoff.
no disqualification in the sense that Malad, supposing it requires the job requires an MA degree and on the date of the last submission I am a BA, I have appeared in the MA awaiting the result.
No, it's not.
Subsequently, Malad, so that's what the line is drawn.
That's a different way of thinking
Right.
because that will open an endless gate. Many more candidates will
Yes,
come in the free.
That is
Now here is a case.
as such we have otherwise on as a matter of principle Malad only. Otherwise we have nothing personal against her or against any other candidate. We will be happy. But the fact remains that Malad, this
Any case for this. Anything.
I'll bring Lordship, because I was going through this eligibility clause because as on 1-1 I was therefore I
No, that is only for age.
yes Lordship, now I'm it's clarified.
If it was qualification as on student,
Yes, because
And-
since it is written and together, so I was under
see the original advertisement.
page 15 of
It-
writ
it-
petition of writ
It is
petition.
not in that manner which you are trying to project.
Page 15 of the writ petition.
See the post, there are 3 columns.
Lordship,
Post, then age as on student,
yes Lordship,
then qualification.
Qualification.
Qualification has nothing to do with the age as on student.
yes. But since heading was written educational qualification and as on, because
Where?
the heading eligibility 5
educational qualification
No, and age on student.
on Lordship, we should read like that. If that is so, Lordship,
as on Malad is compartmentalized in the next column.
No,
that is Lordship is correct.
Had it been both Malad, then he would have definitely he would have a case. He would have a
I read it to the Lordship. The educational qualification read it as on.
No.
But
Malad,
it
Mr.
doesn't
Gopal
also-
Lord, I have gone through the case just now.
Which one?
One case, Chief Manager, Punjab National Bank and another versus Anil Kumar Das.
Okay, I will come back. PNB case.
PNB.
The Ganguly may not be very happy. This on a lighter side. Of this court.
No, my lord, Supreme Court rendered on 3/11.
Okay, just have a look.
2020.
Lordship. Itu kata, itu ni kaya.
Anil Kumar Das.
Oh, itu similar price, similar another.
Yes, written interview on Friday. So to me, just to have taken. Graduate student apply. Because Kumar क्या पता काटिका से एक मिनट.
Oh, to the judgment, Lordship, that is the suppression of, he was already graduate. He did not mention it in the form, Lordship, that is the suppression of.
My lord, that one part and another part that graduation. My lord, page 15 clarifies, my lord,
He appeared for the Guwahati University.
got in part. The qualification, my lord. He got the qualification of graduation on
Page,
page 15.
yes,
My lord, the candidates having completed higher qualification, that is graduation and above, are not eligible.
Hmm.
He got the qualification on 15 February.
Yes.
And he, my lord, applied for the post on 12 February. And that date, my lord, 15 February, the last date of application. And
when did you apply?
12th February, Lord.
paragraph 4.
And in their, Lordship, rejection letter, they have categorically stated that at page 22, Lordship, that is relevant. Lordship.
So I think that broad interpretation, my lord, two
Yes.
interpretations,
12 February, 23 applied.
22, 12th
Okay.
February 22.
paragraph 4, page 5.
They have rejected on the basis of the application dated 12 to 22. That rejection, in the rejection letter, they have stated that.
Oh, yes, what were you saying?
That broad interpretation, since there are two interpretations, that narrow interpretation goes against him. That broad interpretation, the welfare state concept under Article 38. So, Lord, and further, my lord, since he applied on 12, 3 days before the last, that goes in favor of. Otherwise, that, my lord, Supreme Court judgment, Lord Chief Manager, PNB,
What is the application?
Lord, Pakistan is not there, my lord. Chief Manager, PNB, and another versus Anil Kumar Das.
It is
Exactly similar, but only one aspect. The petitioner has suppressed the material fact that he is a graduate. Everything is similar. Earlier it was through interview process. Now only from 10 and 12 March. Post is peon. Relying on several judgments.
2020.
No, it's the 2021 12 is
12 is
12 is page 8. They've got the equivalent.
I think, my lord, basically that interpretation. Last day of application 15, and he has got qualified on 15. That broad interpretation, my lord, under welfare state concept, my lord, goes in favor of part.
page 22
That's my
also,
thought.
Lordship, may peruse once again. May I pray that page 22 maybe.
It's 22.
Page 22, the rejection, wherein they have mentioned about the date of submission of the
22.
22 of the repetition, Lord. It is written, Lordship, with reference to your application dated 12 to 22. That is my date of submission of my form, Lordship. For the post of peon, this is to inform you that the competent authority of Guwahati University has confirmed that as per their record, you have cleared DFNL examination in the year 2021. So, Lordship, they have taken into account of 12 to 2022. So, on that date, I was not a graduate.
Look, as far as the detection letter is concerned, it refers only to the application date, nothing to be read into that. Because there has to be a date of the application. Admittedly, she made it on 12th of February. The last date also admittedly is the 15th of February. Namala, taking a broad interpretation is very all right, too much. Well, but the fact remains that taking a broad interpretation in favor of the petitioner would be taking a narrow interpretation for the next candidate.
Ganguly, matter has become slightly simple.
Good.
Your rejection was on a different footing.
Different.
That
Admitted.
you had applied on 12 to 2022,
Yeah.
and March before that you were a graduate.
Good.
So there is no dispute with regard to the date of application so far your reasons assigned for rejecting is concerned.
Good.
Because you assume that the petitioner was a
Yeah.
graduate before the
Before
date,
the, yeah,
before the date
Last
when she had applied.
Lord,
Because you proceeded on the basis of the grade sheet.
Good.
That was of December 2020.
Yes.
So if you take December 2021 into consideration, that whether it is 12 or 15 does not make any difference.
doesn't make,
As on 12, as a matter of fact, there was no result published.
No.
15 is a crucial date, last day.
Yeah.
He could have applied even on 15.
Good.
Even applying on 52, the assumption may still be in her favor that you are not aware of the result.
Good.
15 it was declared, and you got to know you would
we
know
are
the
not saying
result.
that she suppressed. This is not a case of suppression.
So suppression will not
No.
come.
Suppression is not.
As
That
on
is why
12,
Amit Das case
even
is
if you may not stick to the applied, then also it may not be a suppression. Because it will be a very crucial aspect that while you had given the application, you are aware that you have already passed.
Yeah.
Which is not
that would be also a ground to refuse discretionary relief also. But the fact remains that on the
Okay, okay.
date when the
We'll try
Good.
rabbit. The third year of then it counts for petition. Also heard a Ganguly that is sending count Punjab National Bank who submit that affidavit of opposition as well as affidavit of opposition as well as an additional have been filed by each respondent. The PJ for considered council president what is Guwahati to it. Sarah. I have to say, the grievance of the petitioner pertains to a communication dated 30/6/2022, whereby our appointment as peon in the Punjab National Bank herein of Indian has been cancelled. Sarah. The fact projected is that an advertisement was issued by the PNP for filling up that post, including 5 posts of peon in the unreserved category. Under clause 5, the eligibility criteria has been stated, and stated which contain the age as well as the qualification. Since the issue hinges around qualification, it would be and the qualification, it would be necessary to mention that the prescribed qualification was minimum and maximum pass in 12 standard, 12 standard or its equivalent with basic reading, object writing, knowledge of English. Full stop. The advertisement also stipulates that candidates having completed higher qualification, that is graduation and above, are not eligible. It is the case of the petitioner that he had applied for the same post on 12/2/2022 and has claimed to have met the eligibility criteria, both in terms of age and qualification. Full stop. It is a categorical case of the petition that on the date of such application, the petitioner was a higher secondary pass candidate. Full stop. In the state recruitment process, the petitioner was found had come out successful and was offered the appointment by order date 25/3/2022. You are joined?
No, Lordship. I was not left to that. Interim protection is there.
You did not join.
No, after the issuance of the appointment letter, that rejection letter was,
No, that is 36.
but I
3
have,
months.
I have not read.
Why?
No, because the appointment was cancelled by that.
No, 36 it was cancelled.
Yes, but by the time she had not joined. Not joined.
No, why 3 months? for
25
joining?
days. That I had not. Some communications might have been going on between the. I think what happened thereafter was after the issuance of the
Verification.
the appointment letter, the verification
Okay.
and the communication of the
However,
university.
However, it appears that some verification process was undertaken by the bank, after which, the impugned letter dated 36/2022 was issued, by which the appointment of the petitioner was cancelled. Full stop. The state impugned order, impugned letter has stated that the petitioner was a BA, was a graduate, which he had obtained in the year 2021, and her grade sheet was issued on 23/12/2020. Full stop. Thereafter, Sri Tawildar, the learned counsel for the petitioner, has submitted that apparently the impugned order is erroneous, as the petitioner was not a graduate as on 23/12/2021. Full stop. He submits that the bank itself has clarified the issue in the affidavit, or additionally,
In the affidavit.
in the affidavit position dated 22/9/2022, whereby the matter has been clarified to the extent that the date stated in the impugned letter was mistakenly done, and the petitioner had actually become a graduate on 15/2/2022. Full stop. However, the bank has justified its action by stating that since 15/2/2020 was the last date for submission of application, on which date, the petitioner had obtained the graduation, he was disqualified, and therefore the impugned order is still sustainable. Put the para. So it opens the Senate Council for the petition by referring to the advertisement has submitted that the age as well as qualification are to be reckoned as on 1/1/2020, on which date, the petitioner was not a graduate. Alternatively, he submits that if 1/1/2022 was the date only for reckoning the age, admitted the application was submitted by the petitioner pursuant to the advertisement only on 12/2/2020, on which date, he was not a graduate. It is submitted that the impugned order is unreasonable and unduly harsh, as a hyper-technical approach has been taken by the bank by disqualifying the petition in spite of her eligibility and selection in the recruitment process. The learned counsel accordingly submit that the impugned order is liable to interfere with, and the petition be allowed, be directed to join her. The Senate Council further apprised this court that there is an interim order to keep one post vacant. Para 3. A. Ganguly, Senate Standing Council, PNP, has submitted that the impugned order dated 30/6/2020 has been passed after a proper verification. The Learned Standing Council fairly submits that though there was an error in the impugned order in considering the petitioner to be a graduate of the year 2021, the position would not change, as the petitioner had become a graduate on 15/2/2020, which is the last date of submission of application. The Standing Council fairly submits that the impugned order has been passed not out of any malafide, and but by following the mandate of law. 3. Ukan Standing Council, Guwahati University, has submitted that under the facts and circumstances, two interpretations would be available full stop. While the narrow interpretation by terming the petitioner to be a graduate at the time of submission of application would be against the petition, comma, a broad interpretation may be in favor of the petition. Refugant has, however, placed reliance upon a case reported in 2021, 12 age chief manager came there. The builder, the counsel for the petitioner, is rejoinder, has submitted that the case cited will have no application as it relates suppression of material fact. And in the instant case, comma, there is not even any allegation of such suppression. As admitted, comma, the application of the petitioner was submitted on 12 to 2022, whereas the petitioner, whereas the results were declared on 15 to 2022. Full stop. Para. The private submissions made by the learned counsel for the party have been duly considered, and the material placed before the court have been carefully examined. Para. With regard to the last date of having the qualifications, comma, there are a catena of decisions which based on that qualification of the eligibility acquired after the last date would not be taken into consideration. However, comma, in the instant case, comma, there is a distinction on fact as the matter is not regarding acquiring of qualification, but being disqualified because of overqualification. Full stop. Para. From the materials on record and hearing of the parties, it is not in dispute that there is a requirement that with regard to qualification, comma, a candidate should have the minimum and maximum qualification as 12 standards, and there is a specific stipulation that graduation and above qualification are not eligible. It is also not in dispute that on 15/12/2022, and it is also not in dispute that on 12/2/2022, when the petitioner had applied for the post, comma, he was not a graduate, as the results were yet to be declared. Full stop. there was no stipulation in the advertisement that persons who were pursuing any higher course above higher secondary would not be eligible to participate in the recruitment process, provided that such qualification was not possessed in the mean. Sarah, there is another aspect of the matter which would be revealed by a careful reading of the impugned order dated 36/2022. The letter proceeded with the presumption that as on the date of the application, that is 12/2022, the petitioner was a graduate, and the same conclusion was based on a grade sheet issued on 23/12/2021. It appears that the only consideration for cancelling the appointment of the petitioner was on the presumption that he was a graduate of the year 2021, and as on the date of the application dated 12/2020, 2021 and 2021, and therefore he was not qualified to submit the application, which was done on 12/2/2020. The affidavit of Jack has, however, clarified the issue that the cancellation was on an erroneous presumption that the petitioner was a graduate of the year 2021. However, with a rider that the results of graduation were declared on 15/2/2022, which was the last date of filing of the application. Sarah, in the instant case, as is mentioned above, there is no dispute that on the date of filing of the application, submission of the application, that is 12/2/2022, the petitioner was not a graduate, and this is an admitted. Therefore, the question of suppression of an material fact, which was sole consideration in the case cited in bracket Departmental and Supra, which was sole consideration, the case of would not be applicable. This court is also of the opinion that the order dated 30/2020, which is impugned in this proceeding, has to be adjudicated by the contents of the same, which apparent has proceeded under the assumption that as on the date of filing of the application on 12/2/2022, the petition was disqualified as she was a graduate, and this finding of fact is an erroneous one, which is also admitted by the bank in its affidavit in opposition stated 29. For ready reference, the relevant reading of the said affidavit is extracted here below. Paragraph 10. 10, right? Paragraph 10,
Paragraph 8. Page 36.
8 or 10?
Can you also? No, the 8 and 10 both.
Okay,
both.
paragraph 8.
Yes.
It's 30. That being the position from this court is not required to go to any other respect of the matter, as it is the impugned communication dated 36/2020, which is not followed by any collision which is required to be adjudicated. Even otherwise, this court is of the view that since on the date of submission of application by the petitioner, which was 12/2/2020, the petitioner was admitted not disqualified, her candidature could not have been cancelled on the ground of overqualification. This court is also of the view that the law laid down on the cutoff marks are only with regard to acquiring of qualification and may not be applicable in the instance case. Further, this court has noticed that the selection was based on merit in which the petitioner was found to be most meritorious. This court is of the view, meritorious, which was followed by an appointment letter, this court is of the view that the cancellation order is unduly harsh and unreasonable. Accordingly, this court is of the opinion that the impugned order dated 36/2020 is unsustainable in law and according to the same is satisfied. So consequently, it is direct that the petition would be allowed to join and discharge the duty on the strength of the application, on strength of the appointment order dated 25/3/20. The petition, it is however made clear that the petition not entered to any back.
Obliged.
Yes,
Please,
Mr.
Lord. My lord, on the last occasion, my lord was pleased to hear the matter, my lord. The matter relates to, my lord, the issuance of the second so-called notice, my lord, on the same set of charges.
Okay.
In respect of the first charge, my lord, I was exonerated from the charges, my lord, and thereafter, my lord, a case so-called
Yes,
notice has
Mr.
been issued.
Lord,
I don't take up this matter next week, madam. I'm not very well, madam.
Hard free RM Decca Leonard Council. He had informed you perhaps before
My lord,
regarding his condition. You were informed.
today morning, my lord, after the court.
What ailment? Physical or mental?
No, my lord, last 5 days I was down with viral.
Doesn't look like.
Viral fever.
5 days was holidays. Something else might have happened.
No, my lord, I couldn't come out of the house on 5 days.
Do you know you were under a scanner? You are being watched. There are video footings, live streaming. Where he had gone, what did you do?
It is a giving a statement, my lord.
The holidays are responsible, my lord, for his health.
Holidays are responsible.
Amen.
So for him, no vacations in Puja. RM Decca Leonard Council. Para 3, Art or State Council was submitted that he is not is not keeping well, and the matter may be taken up in the next. So, para, fix the date.
Yes, my lord.
Accordingly, matters can be proceeded on.
14th, my lord, next Thursday.
14th we have matters.
13th,
15th,
15th. my lord. Interim order may kindly continue.
interim order passed to continue to the next.
Now obliged.
Even madam is not well.
No, Lordship, I have
She was sleeping for a long time, peacefully, without any disturbance.
Perhaps with the thought that he will be able to stop me on my
Maybe she
tracks
was
and.
gathering enough time to counter you.
No,
Yes,
that-
ready for
only-
disposal.
Otherwise, I'm ready. My lord. There's only one aspect of the matter. Which
What is the matter?
My lord, it's regarding a de novo court of inquiry being instituted by the respondents, which I'm challenging in the writ petition. There was already a court of inquiry held on the same allegations. My arguments are
Madam?
full.
Lordship, I have filed a IF for vacation of the stay, Lordship. That is not considered, and the Honorable Court on 19/7/2023, there is an order, Lordship, that it should be finally disposed there, Lord.
If
I
you are
can-
ready for disposal,
Yes,
we take up for
sir.
disposal.
The only issue would be, my lord, I have alleged that there was a court of inquiry held prior to this court of inquiry on the same.
What is the
They do
penalty?
not- they-
Dismissal.
My lord, no. It's on the court of inquiry level stage, my lord. Whether
Okay.
they have the authority to initiate the second court of inquiry when once it has been done, number one, and in.
What was the, how did first put to inquiry?
My lord, I was, no guilt was found on me and the entire incident was held to be an impossible act. What had happened is they had alleged that I had
They
been,
had come to a finding.
yes,
Court of inquiry had come to a finding.
Yes.
You have the record.
that opinion, the opinion of the court of inquiry I have on record. And they do not place it before this honorable court, the records of that earlier court of inquiry to show whether it was a preliminary inquiry or a court of inquiry. Now, if it was a court of inquiry,
If
it
you
was
have
on-
made a statement, is it been denied?
they try to contest it by stating that it is a preliminary inquiry, and therefore, my lord,
Record,
particular, only for that inquiry record, if they bring it
otherwise you
on
have to
record,
draw inference against you.
I can simply.
Lordship, our submission is that not, it is not
Submission.
actually a court of inquiry, some preliminary
No,
inquiry
you
was
produce
there.
the
Lordship.
record. His main foundation
Lordship.
of this case is that there was an earlier court of inquiry, which you termed to be a
Preliminary.
preliminary inquiry. You
Okay.
show the record is a P, not a regular one.
The order will show whether it was a court of inquiry or a preliminary inquiry. If it's a preliminary inquiry, I go to my other arguments. If it was a court of inquiry, law says there's to be one
Lordship,
court of
that,
inquiry, matter ends.
He had annexed the opinion of the
Yes.
presiding officer, Lordship, and Lordship,
What is the allegation?
he stolen of 25 barrels of kerosene oil,
Kerosene.
ITBP. This is not the only
You
prior.
have a kerosene shop.
My lord,
You have a kerosene shop.
what they say is, my lord, that I had carried those 25 barrels of kerosene in a truck,
It is not
And
kerosene,
slowly-
it is SK oil.
SK.
What is SK?
Superior kerosene, maybe like
Subsidized kerosene.
subsidized may
If
not
I'm
be
not
because
wrong.
he is an ITBP.
No. At that point of time, kerosene oil was subsidized and they had mixed that particularly. Am I wrong on that? Not so bad.
Okay.
I'll find it out.
Yes,
The earlier inquiry.
allegations are serious. What was your posting?
My lord, I was there as a deputy commandant.
Deputy Commandant.
The commandant held the inquiry
Uh,
on the orders of the then IG. AIG.
Where is your order? Where is it, the document from which you have laid the foundation?
My lord, will find it at page 18.
1/8.
18 is the first inquiry report.
Prior to that, Lordship, we have also taken the ground of maintainability, Lordship,
We'll come to that.
because the course of action is Leh and Ladakh. The incident took place when the petitioner was posted there. Inquiry was also initiated there, Lordship. And now the petitioner was asked to appear before the court of inquiry. They are itself only, Lordship.
Present, impugned
Present,
inquiry.
Yes, Lord.
Now you're posted here.
I am posted here. I am depending upon an order passed by the ADG here to protect my rights. And therefore, the part of action, cause of action will arise in Guwahati High Court. I'll post it from my several judgments are there on this level. Lordships,
What is the part of cause of action which is arising
my lord,
under
the,
this code?
the additional director general in Guwahati has issued an order prior to this court of inquiry holding that there will be no inquiries held on anonymous complaints. This is based on a CVC circular. Lordship's order is there to show that CVC circular will be applicable to the petitioner here also. Now, when
For
I-
that, with a cause of action, that's not a
Madam,
cause of
that
action.
will be a cause of action. Madam, how I
That
try to
you
show
can-
is
You
it
can,
is-
you
it
can
is-
gain, you can derive some right from the communication, but that's not a cause of
my lord, the cause of action would, in my
What is
humble
the cause of
sub-
action?
my lord, the cause of action
The
is
cause by which you are aggrieved.
no, my lord, the Honorable Supreme Court has defined it a little differently, my lord, if I have understood it correctly, to
It's a
say
bundle of facts,
that
but
any
ultimately
bundle of fact which I need to show, I need to prove to show that I have a relief from this court. Now, an order passed by the ADG is the very ground on which I have based my entire case upon. There are two grounds, of course. One is the de novo inquiry part, which they have to bring the records to show before this honorable. Otherwise,
Now,
For
what
this
prejudice,
honorable
what
court's order.
prejudice do you suffer by having this, using this communication by which complaints which are unnamed or
my lord,
anonymous complaints should not be taken into consideration?
my lord,
That is a general circular.
that is a general circular which, if they want to say that it is only in Leh and Ladakh, when my relief is based only on an order here and the former convenience matter where forum convenience matter where they have filed an entire affidavit in opposition answering the entire writ petition.
Where?
This court. They have answered it in this court. They have the records in this court. They have their offices in this
No,
court.
no, that is
Everything
okay.
lies here, and therefore, my
This
lord,
is only because they are contesting or they are not suffering any prejudice. This may be some grounds, but if they are very adamant or they are serious in the issue of jurisdiction, they have to make out a case.
my lord, yes, they have to make out. They have
No,
to
no,
show
you have
that
to
it-
make out a
my lord,
case.
they have to show that
They
none
can
of the
raise
cause
this
of action.
different issue.
My humble submission will be, my lord, they have to show that no part of the cause of action arises here. It would not be upon me to, my lord, show that
No,
yes, there
first
is
the burden is
substantial
up-
cause of action.
First, burden is upon you to show
Yes, that is
that some part of action is
that
under this code.
that is what I was trying to, my lord.
No, that letter perhaps will not be enough. Let us see that letter,
Which letter, my lord?
which the letter of the ADT here.
Because it
Which you
depends on
There will be
the
other,
basis of
other aspects also, my lord, I agree again. Today, I was mostly prepared on the line whether they would be required to produce that particular record to show.
No, sir,
The
madam
government
has
certain
raised
who,
the issue that it was on Leh Ladakh and you have come to Guwahati.
that we have raised in our
that will, my
affidavit.
lord, I'll try to convince lordship from the Supreme Court judgment.
And-
So otherwise, lordship will have page 33.
This is on the basis of
Which
CVC.
decisions are you referring?
My lord, the 2020 judgment, my lord.
Sure.
That is Shanti Devi versus Union of India is one of them, my lord. I'll refer to that. But if you would like to have it after the lunch, I'll have the list of books.
You must-
My lord. Then there was another one. The Nawal Kishore Sharma, my lord, I'll be referring to it. And there was one judgment, my lord, the Guwahati High Court, my lord, where that is lordship appeared in the matter where the registry, there was one person who had attacked the registry of Arunachal Pradesh, my lord, session process. I had gone through it, but I found that it was mostly on the basis of whether the proceeding could go on ahead with the after submitting of the written submission. That was not exactly on the territorial jurisdiction part. So I have not got that on. But Nawal Kishore
Okay,
and the
we'll have
2020
it,
judgment.
we'll have it. No,
These two,
bring the judge.
so
There is an
it's
often,
right.
often cited judge.
My lord,
There is one judgment often cited for part of further.
part of cause of action.
Okay, let's go.
I'll stop. Perfect. PC. I have not been able to find anything specific on the issue as to whether when a person is posted at a certain place of posting and he receives an adversarial action, a notice of an adversarial action from the respondents, which is issued from some other territory, whether this would hold the field or not. On that aspect, whether if I can
You are
get
still
some-
in service
I'm in service, I'm serving
and
here.
you are serving here.
I'm serving here. My controlling authority is within the jurisdiction of this honorable court here at Guwahati. I am, if for assumption's sake, my lord, if the territorial jurisdiction is denied here, then it will be upon me to go to another place where I will have to face consequences of having to proceed in litigation there without much help from the department. But here, when the entire office of the department and everything is available here, I serve here. And therefore, adversarial action initiated against me from another place when it is defendable here and my service is here.
So that last
That
submission
part-
is not a submission is acceptable in law. If you go by the place of doing,
My
is
lord.
where the defendant resides or the cause of action.
So where the defendant
You
resides.
reside, your residence is
No,
not,
no, what I'm trying to
not
say is that
relevant at all.
it is,
And your the harassment or whatever
if
that
we,
which you would suffer as a plaintiff,
I-
it's nothing to do with the case.
what I was trying to
Because
say,
the objective is the defendant should not suffer because of politics.
that is what I was
But
trying to say.
since you're serving here
I'm serving
and
here.
your connection is not severe, so perhaps we may take a lenient, different liberal approach. Not
And because
liberal approach.
to add to it, my lord, if I may just add to it, it is not a case where they are not in a position not to defend it here at all. Their defense here
That is
would
not
be as formidable
that
as,
is not a relevant consideration.
because that is
That is
why
not a
the residence of the respondents, the convenience of the
No,
respondents.
it's not a convenience. It's whether if defendant resides.
So the defendant
problem?
resides here, my lord. The persons against whom I'm having the allegations, the person against whose orders I'm trying to have implemented for my protection are here. So in case, my lord, I need to
Okay,
argue
you
further
pro-
on this, my lord, I'll need some time to just go to find out.
No,
which
madam,
service matter part.
I think you need to produce the record. Because the first point, even if we take a liberal view and we proceed with the merits of the case, then his foundation is the preliminary inquiry, which you say is preliminary and
I say it was a
Is
proof
the-
of inquiry.
court of it.
But yes, Lordship, that-
Have you stated in your affidavit?
Yes.
Yes, in the
Right.
affidavit, they have stated that it is a preliminary inquiry. And
Lordship,
That's
He-
your affidavit.
on jurisdiction point, Lordship, he is relying on a document also from here, Lordship,
Yes.
but he has to rely on where his right has been infringed, but that is for his benefit only. And how he rely on a document
in
on the
the
ground of
affidavit-
jurisdiction also, which is in his benefit, because that is of 31/2023, and the impugn order is of 12/2023, so prior to issuance of that order. And more so, Lordship, that is issued on the basis of a CVC guideline.
No,
and
no,
CVC
that aspect we may not even go in. As we have told earlier, that is a general kind of thing that
running
unanimous
page 37. of the-
anonymous complaint are not to be. From that is no cause of action arise.
Got it.
That's a different matter.
Yes.
But we are on the different part where you are deciding whether there is a difference between the respondents here and the respondents who have at place.
Initiated the proceeding there.
Ultimately, you are controlled by the ministry.
Mayor residence perhaps, because he is not a resident of, he is posted here.
No, his residence is not the concern.
Lord,
Concern is the defendant reside.
just the defendant is Union of India, so all over India, but then also Lordship, jurisdiction will come, Lordship, because
That's good.
Union of India is in one case.
So
Lordship,
since
we
he
have-
is posted here and the relationship of employer is still not severed, so I think that should not be too much.
One judgment
on
is there, Lordship, that I have annexed also, Lordship, that there should be specific pleadings in the writ petition that this court has jurisdiction. But there, here I have not found any such pleadings in his writ petition also, Lordship. In fact, Lordship, he has not argued on the point of jurisdiction also, which I have specifically mentioned in
Where
my
is your
affidavit.
objection regarding jurisdiction?
Lordship.
The lordship will find it key.
My affidavit, Lord, I have annexed a
Running
number of judgments of different High Court and Supreme Court. Lord. Preliminary objection
Page 39 on my lord.
39.
Now we have that, which part, which paragraph?
Paragraph 7, Lordship, page 39.
Yes.
The long one I have relied on certain judgments also, Lord, and annex also. Judgment here, Lordship, corrupted court.
Where you stated on marriage that
It's a preliminary inquiry.
Yes.
Lordship.
At, which you find there at page number. Sorry, I can't read.
Yes.
Page 37, my lord, para 5.
page 37.
Para 5, page 37 of the affidavit, the running page 37 is how they have marked it to me. Otherwise, affidavit no position, para 5. Third page. The petitioner in his petition has alleged that the renewable.
Was in the nature of a, was in
this
the
regard, it is-
nature.
in the initial inquiry was conducted was in the nature of a preliminary inquiry, not an inquiry as mandated under Rule 175 of the IT Rules 1994. Such inquiry was conducted in order to ascertain the
Madam, you
veracity
produce
of
the
allegations.
record. If it's a preliminary inquiry, his rights are restricted. He cannot be.
Yes.
It's only a fact-finding inquiry,
Not-
discrete inquiry, only to proceed with the main inquiry.
Lordship.
But if his contention is that it was a court of inquiry, then matter of it. Where are the records?
Records in left.
It has not been presented to you.
No.
Send the records.
The
Your scan copy will also do.
Lord.
Do you want to see the notice?
Lordship.
Scan copy.
regarding the earlier inquiry,
This
this inquiry would be assigned because
this
this-
inquiry is we only want to see the
earlier
since we are having the
inquiry.
records, get the entire record.
Yeah.
But we are more interested to see how you have substantiated your point.
If possible, I will get the whole record. If not, then the scan copy of the original
Yes,
first
yes.
inquiry, Lord.
First in.
Heard. We are for the certain counts, but it is also heard detail on the appearing for the issue involved an inquiry which according to the petition, the issue involves the prior inquiry which according to the petition of the court of inquiry while the respondent contended that it was a preliminary inquiry. So, the state aspect could have relevance to the adjudication and therefore the records of the case, records of the proceedings would be necessary. since the record, which are stated to at least that the record be produced by MS Sharma, which can also be the form of scanned copy. The objection para, the objection regarding the preliminary objection regarding lack of territorial jurisdiction would also be considered by this court. If we get open,
May kindly keep it as part hard lordship.
no, not further. We'll fix it if you want.
Lordship on hard it on jurisdiction point lordship may kindly keep it as part hard lordship. On
We'll have a date because you need to produce the records. When can you produce the records?
lordship on 26.
As agreed to by the parties based on 26 or 26.
20,
20.
not
Or
26.
26.
26.
26, Tuesday.
Tuesday.
26 9.
The interim continues, it was till today.
Is there any interim order?
Yes, Lord.
Interim order passed at the next day.
Okay.
Bless.
I'm prepared with this case.
I've gone through it, my lord. Whether it applied to a service matter as such is what I'm trying to find out.
My lord, as per the last order, my lord, the respondents were directed to take instruction in respect of payment of subsistence allowance. My lord. Kindly peruse the last order, my lord.
Yes, yes.
On 28/8/2023, my lord.
Yes.
You have
So
not
do not-
received any instruction.
Instruction, please. It has come up for the first time last
No, my lord, notice has already been issued, my lord. My lord, kindly peruse the last order, my lord, 28/8/2023, passed by lord.
right.
And my lord, we have an interim prayer, my lord, for payment of subsistence allowance.
We'll give a last course, last few days were holidays. Today is Thursday. We'll have it on Tuesday, Wednesday next.
My
But
lord.
we'll consider it interim.
My lord.
Not the interim, we'll consider everything. Okay. Part 3. Decca. Senate Council for petitioner. Whereas the department presented by Senate Council, Sri Devnath. Sarah? Sri Devnath. Senate Council. However, submit that this was the final opportunity.
Yes, my lord.
Submit that because of preceding holiday, instructions could not be obtained as per the direction dated 28/8/20. He according to place for some more time. As an exception case, time is granted Wednesday next when the matter to consider.
My
Sarah, please stop. Wednesday,
13.
why two matters?
My lord, there are two petitioners, my lord, of same text. And deeply obliged.
The lordship may pass over a matter for time being. Mr. Nath is in court number 12.
12 to
14.
for review matters.
The review it.
I think it's on the way.
He's on the way.
Can start. Who's the review?
No,
The state is here.
your lordship has a look on the past order, my lord. In the review petition, your lordship raised one point of preliminary objection as to the maintainability of on the ground of delay.
Which order?
Past order itself in the review.
First order.
Past order.
Yes, yes.
Therefore, the judgment on order was passed on 26/22, and review was filed after 5 months.
Yes.
Even
Lordship, the matter may be fixed after some time, Lordship. My senior is on legs in another court.
Is he still on legs or is he on the?
Still on legs, but it will be over soon. Lord.
We'll take on this point, I think we'll decide.
It is covered by the division bench of this honorable court. Not a single whisper as to the cause of delay. No, just
Obliged.
Sir, otherwise, what is round of review? Mr. Sharma, Dr. Sharma, just a minute.
right. What they want to say that our appointment itself is a temporary appointment. That they want to justify that, nothing more than that.
Temporary
As supervisor, which is the cadre post.
At that point, we have covered the ordinance.
Already your lordship decide that point.
I appear for some of the respondents in this dispute. What has happened? The points which have been taken in the review petition has already been argued and considered in the judgment. Lord. Point number A and B, ground number A and B is covered at para number 18. Ground number C regarding the point number A and B is concerning the finance concern. There is no finance concern. That was argued and decided at para 18. And point number 3 is the mode of appointment. Mode of appointment
Yes,
is
Mr.
also argued at para 12. Therefore, it is covered by the judgment of 2013. Kamlesh Verma.
Okay, we have sought review of the judgment dated 26/2022. On it,
20,
order of the honorable court is dated 26/2022. That page
28th of June.
20th of June. But the review petition is on a narrow campus. Lordship kindly come.
No, what about the delay?
Delay.
The Lordship, we filed the petition. I have take the record, madam. But we filed the petition on 25th of November. After the, but there was some defect. We could rectify the defect on some defect on 3rd of January, and the
No, it was filed on 10 January.
no, it was on 3rd of January. It was 3 defects were there.
Defective filing is not filing.
The
Petition will not be saved by limitation.
the Lordship kindly come. See, my lord, the office there is a note of the filing section.
What is the law on this?
But
What is the law on this? If you file an appeal just to save the limitation, appeal is filed defective. I'm on a different analogy. Just suppose there is a period for 60 days for filing an appeal. The time is running out. So what you do? You file the appeal.
In fact, we filed the review petition with a supported by an affidavit of the deponent. The registry said that the filing section said that some certificate has to be there. We
Not certificate. What some certificate? As you're a layman. If the review needs to be have a certificate, High Court rule.
no in with the affidavit we filed that.
That is not. We will not go in that. We will go by the filing stamp of the 10 January. 10/1. But first you have to tell us why we should entertain your petition after the petition.
The Lordship, in my respectful submission,
in a writ petition, my lord,
We have indicated in no uncertain terms. We have given that citation of the Constitution by Bhailal Bhai, Zero MP, paragraph 23, I think.
Sure.
See the language of 20. Have you got the decision, Bhailal Bhai?
No, in fact, my lord,
No.
relying on Bhailal Bhai, my lord, this honorable division bench of this honorable court held that the review petition must be filed within 30 days. If any delay, there must be some
Bhailal Bhai has clarified that in a writ proceeding, that same thing will be applied.
applying.
my lord, there is a decision of our court, my lord, that in a writ petition, against the judgment of a writ petition, review petition limitation will not
Will go by the Supreme Court. Sorry.
will not.
That single bench judgment was clarified by the division bench judgment. So Lordship can have a look on it. Division bench judgment, relying our division.
Because that's this is the Arunachal matter.
Yes. Relying on the Bhailal Bhai, my lord. Paragraph 5 and irrelevant paragraph at 9, my lord.
Here, Bhailal Bhai was considered.
Oh, my lord, paragraph 5 by Bhailal Bhai was considered. Has your lordship got it?
Yes.
Next, paragraph 9. Because what has been discussed and pointed out above, while we agree with the observation made by in the case of Konak Chandra Sharma, that the Article 124 of the Limitation Act would not apply to an application for review of an order passed under Article 226 of the Constitution of India, we clarified that the High Court would not ordinarily entertain an application for review if the same is made beyond the period of 30 days as prescribed by the Limitation Act, on the ground that the public policy is not to ordinarily entertain an application for review beyond the period of 30 days from the date of making the order. It would, however, remain open to the High Court to entertain in a given case an application for review even if such an application is filed beyond the period of 30 days, provided that the High Court is satisfied the applicant has sufficient reason for not being able to apply for review. There was no such, my lord.
Have you pleaded any?
No,
any
nothing.
difficulty?
No, my lord,
Nothing.
no, my lord, in the review petition, that delay in filing that I have not. I have not.
Can you see the language?
Lord.
What was it? 1964.
1964 AIR 1964 SC 1006. Sir. 100.
Not 20. What was the paragraph? 20, not 20.
Seven.
It appears. Violent. It appears late.
Paragraph 21. Come to paragraph 21.
Lord.
You can keep the first two, three sentences.
It appears.
Just after he argued that assuming that the remedy of recovery of loan is civil court should bar or date of dispense, so that would be no reason to refuse the relief under section 226 of the Constitution. Correct? The learned counsel is right in his submission that the provisions of the Limitation Act do not as such apply to the granting of relief under 26. It appears to us, however, that the maximum period fixed by legislation may ordinarily be taken as standard for delay in Article 26. The court may consider the delay unreasonable, even if it is less than the period of limitation. See, prescribed for a civil action for the remedy, but where the delay is more than this period, it will almost always be proper for the court to hold that as unreasonable. Even if it is within limitation, writ court being a court of equity may not entertain. You may have a case for admission in the civil court. You may say that it prescribed period of limitation. Writ court may say no. Even that may not be. And where it is out of limitation, it's gone. Yeah, have you say, I wanted to read out because of the language used. It will almost always be proper for the court to hold that is an always. And why almost? You still have a chance to explain to the court, maybe not by fighting any other petition, even in this petition, that these are the reasons.
Look.
You have not come up with any reason.
Well, strictly in the review petition in the body, we have not said, but the after receipt of the judgment, because of the state is.
There was no prevention on your part to file, to plead anything or to file an additional affidavit. Nothing.
Correct. Under what circumstances, we could file the review petition, although it is defective, on at least on 25/11.
Not like going to the marriage.
That
Mr. Bora was trying to point, Mr. Koto, Mr. Bora was there, all of your grounds were being considered by the judgment, and if you're active, you go for an appeal.
On marriage, since the question of limitation.
When the
has come,
limitation, your lordship will not.
now
This
come
will
on.
not go through jurisdiction.
If you are successful, it is almost impossible to overcome the hurdle of limitation.
Malad.
Even on marriage, we may have a great difficulty in entertaining a petition because these points which you are trying to now raise were already raised and considered. This court has taken a view. These views are subject to corrections. You can test these views. These views may not be correct. It's up to you.
Without answering to the issue of limitation, if lordship on merit, I have to point out one thing, because on the face of the record, I have one submission on merit, but the first hurdle is the limitation, the circumstances under which, if lordship kindly gives me 1 day time, by tomorrow I'll file, lordship may take it.
No, that at this stage will not. You knew why will not keep the incident the first day. When we taken out that, and we not only pointed out, we had given you the case. The constitutional bench has said that limitation act, though per se may not be applicable, it is applicable, and writ court, the limitation for writ court is even more stringent and rigid. Even if it's say by limitation in few cases, the writ court may say that you are there is latches on your part.
Correct.
It's more of a question of latches, may not be delay. So ultimately, it's the equity court.
It is the reason for the delay, the tenure of delay.
We are concerned whether you are negligent in dealing with in coming to the.
Correct.
Only because limitation is there for 3 years, you wait till the third year.
No. We are
in a given case. Writ court may say no. These are cause of action. It should immediately come to the court.
But after the judgment passed in the month of June,
And in those cases where salaries were concerned, division bench has said that only those contractual bills, only those which are within the period of limitation may be entertained by a writ. Those who are outside, if a civil court is barred, writ court also cannot pick up.
Moreover, Lordship would see that on 25/11/2022 it is filed. Normally, the registry notifies the defect within 3 days. Now it is cleared only on 3/1/2023. That is the most negligent part. It is notified within 3 days,
No,
but
we'll, Mr. Bora, we will not go into the respect. We'll go by the official date. It is Jan 1, 2020.
Yes.
Effective filing is no filing.
It was notified on 1st of December, and but from our office, there is some, we could rectify it on 3rd of January. That is correct.
We'll discuss this review on the ground of it without saying anything on merit. File an appeal.
But on
We'll know and will not enter into the merit. May have further problems. You may have good grounds of
the circumstances under which we could not file it within 30 days. That
you have not pleaded.
we have not.
In absence of
that-
pleading, why should we hear you? Why would I allow the council to address this court
Correct.
on a point which is not even been pleaded? And these are
Look.
essentially points of fact. This is not a point of law. That these are the circumstances, these are the for which I could not come.
In
It
fact,
cannot be a law point.
in fact, in my affidavit in reply, my lord, I have specifically pleaded. And that too, there no reply has come.
now on 2/9/2022, the contempt petition is filed. It is the outer limit for complying with the judgment was 2 months. Lordship. On 2/9, contempt petition after that, for the contempt only this review petition has been filed.
2/9. Okay.
But at the government level, for taking decision, sometimes time will take.
We are not, will not give you any advice.
Sir.
It's up to you. You have not paid for extension. You pay for extension.
Extension, we have not paid that. That's the.
A recent order of your lordship on 27th 4/7. Lordship.
You want double dismissal over.
No, Lord.
One order of dismissal or two orders. Mean the same. So have you seen?
But I humbly reiterate my prayer just for one day.
Tina, appearing for applicant, the state of Assam, which has filed this application in the state of Assam, and the officers who have filed this application for review of the judgment and order dated 26/2020 passed in WPC 7215 of 2018 by the state judge, the respondent, the state respondents were directed to provide the service benefit to the petitioners who were working as supervisors in the social welfare department from the date of the initial appointment made on 6/2016 along with other benefits. Full stop. Para. Also heard the as counsel for the whom the
For respondent number 1-326-8-11.
kindly give us.
No, Miller, in my affidavit in reply is there.
Give us, and Mr. Bora,
Yes, I'll give.
2/7.
give us. And three people for us for the response pursuant to who were writ petitioners. In the there were two writ petitions though.
One
Bora was for another writ petition of
Earlier one repetition, Miller.
Now the private respondents, they have come up in two groups. They filed two contempt cases.
no, how can Bora be a petitioner? The main case.
No, for some petitions,
In
he
the-
has filed a contempt case.
No, no, we are referring to the original thing.
Original all, for all petitioners.
You had appeared.
Mr.
Okay,
Bora
okay,
appears-
okay, then we write respondent. As Kotogi for respondent number so and so, and Sri BP Bora for respondent number so and so, who were all the writ petitioners.
My lord.
Full stop. There. Before going into the merits of the case, this court by order dated 10/4/2020 after noting the date of the judgment and the date of filing of the review petition had passed the following order. Order 10/4/2020. The state order, the respondents within the writ petitioners had appeared thereafter. Full stop. Para. It is the contention of the respondent that contempt petitions were filed for the judgment dated 26/2022 as the period prescribed by this court of 60 days was over and no action was taken for compliance of the judgment. And only as a counter blast, the review petition has been filed. Full stop. Para. The now the learned senior government advocate Assam, however, submit that there were circumstances for which the review could not be preferred within the period of 1 month. Full stop. He further submits that the review petition was presented for filing and due to certain defects, the date of filing has been given as 10/1/2023. Full stop. Para. On the other hand, both Sri Kotoki and Sri Bora, learned counsel for the respondents within the writ petitioners, have contended that in terms of the case of Hailal Bhai, decided by the Constitutional Bench of the Honorable Supreme Court, the question of latches, delay and latches, the Limitation Act would essentially arise, and even if a separate application is not filed for continuation of the delay, pleadings were necessary to be made, supported by an affidavit to explain the delay, which is conspicuously absent. It is submitted that there is not even a single statement in the application explaining the delay. Though certain explanations have been tried to be given by Sri Nath regarding effective filing and certain circumstances causing the delay, in this court would not take a different view other than different view regarding the date of filing, which according to the office term is 10/1/2023. Full stop. In any case, a defective filing cannot be construed to be a proper filing and therefore would not save the limitation. Full stop. Srinath, the State Council praised for some time, had also prayed for some time to file an affidavit in regard to Sapera. However, the initial order pointing out the aspect of limitation having passed on 10/4/2020 and no affidavit of the application being filed till date, this court is not inclined to grant any time. Though it is pointed out by the learned counsel for respondents petitioners that the grounds sought to be urged in support of review application were extensively considered and decided in the judgment dated 26/2022. Since this court is not inclined to entertain the review petition on the ground of delay, this court would not enter into the merit of the ground urged. Full stop. In view of the above, and by following law laid down by the Honorable Supreme Court, or by the Constitution bench of the Honorable Supreme Court, in the case of Hailal Bhai Supra, the Constitution bench of the Honorable Supreme Court, in the aforesaid case of Hailal Bhai Supra, has laid down as follows. Following the aforesaid law, which is also followed by a division bench of this court in the case of Modi Riba versus reported this court is of the opinion that on the ground of delay itself, this petition paying for it is not mentioned, and according to the same. What about the other cases?
Contempt, my lord.
Those are contempt, my lord. My lord, in contempt cases, my lord, I am appearing for the respondent. Lord, you may grant me some time, my lord, for filing affidavit.
Why was this Noorlal Verma?
That, my lord, that already dismissed. It's not necessary, my lord.
You have not filed affidavit?
No, my lord, I have not. Lord, I'll file, my lord. Lord, you may grant me some time.
If it will comply with the order, you file an appeal. Yeah, contempt you, right? But both one is by you.
In one contempt petition.
Now the petitioners have filed two cases, my lord. Some are by.
Yes, two in both the cases you have not filed affidavit.
No.
Third, as court of counsel. Within a learned counsel, appearing for respondent, pray for and is done 3 weeks time to file affidavit. Please stop. Yes, Dr. Sharma, what is this?
This is a contempt petition. And the order passed by this honorable court starts from page 9, your lordship. The relevant portion at page 13, paragraph 10, your lordship. There is a
Who's for the
none.
first time it is done.
Yes, sir.
So nowadays it comes for orders.
Yes, sir.
Yeah.
It comes in order column.
Where is the
Page number 13, para 10, your lordship,
1-3, paragraph 10?
paragraph 10. That is the
Is the pension.
order of-
It is.
that has been violated, your lordship.
Yes, where is your
Lordship.
where is your representation? Where is your representation?
Oh, that I have not annexed, your lordship. That representation, lordship, was for remission of the penalty, your lordship, imposed.
No. Where is the forwarding? Where is the letter by you by which you have forwarded the judgment for compliance?
That I have not annexed, your lordship.
For a
But then-
contempt that is necessary, Dr. Sir. You have to intimate them that this is the order, comply with it.
But
This is a contempt jurisdiction.
after my representation, your lordship, after my,
We are not on the representation which was filed prior to the judgment. We are on the forwarding letter after the judgment, which is required to be given by forwarding a copy of the judgment and requesting compliance. That has not been done.
that I have not annexed, your lordship.
You have to annex. We'll keep this pending, will not cause prejudice to you. Immediately, tomorrow itself, you send a copy to the alleged contemptor.
Hmm.
And after 4 weeks or 5 weeks, you file an affidavit
No,
annexing that.
that I have got, your lordship, the receipt copy.
So you have already forwarded,
Receipt
you
copy
have
is-
it.
Yes, your lordship.
Then you can just file an
I'll
additional
get
affidavit.
it from the petitioner, your lordship.
To this petition alleging contempt has been filed for a judgment and order for a judgment and order 22/5 passed by the court in WP 6880/2015, by which the pensionary benefit by which the pension and other retirement benefits were directed to be released within a period of 60 days from the date of receipt of a certified copy of the order, it appears that in the present petition, such forwarding letter has not been annexed. Sarah, Dr. Sharma, the learned counsel for the petition, however, submit that he may be granted some time so that the alleged contemptors can be intimated about the judgment, if not already done, and file an additional affidavit to bring on record the copy of such letter by which the judgment was intimated. This after 3 weeks? This after 3 weeks or 4 weeks?
2 weeks, maybe.
But have you actually sent or not?
Not yet.
If you have not sent, then
No, it has been sent, they have received it also, your lordship.
then 2 weeks. Because if you have not sent, you have to give them adequate time for compliance.
That was
2 weeks.
obliged.
Yes. Yes, sir.
But the stopwatch was issued. in
Who
a-
are you?
Well, I am a junior inspector, my lord, of Property Society.
Okay.
And stopwatch was issued, that is at page 13, annexure 1,
For
having 3 charges, my lord.
then
Then, my lord, there your lordship will find in the
page 30.
page 13, 1-3.
One.
The 3 charges are there. Charge number 2, your lordship, was related to 41 lakhs 76,900, then 22 lakhs 16,141. Then also charge number 3, your lordship will find there is a 12 lakh amount are involved. Then your lordship find in the next page 14, list of document.
Yes.
This letter, my lord, is 3123. So this letter, while issuing this charge sheet or communicating this charge sheet, the petitioner was not furnished with this document. So the petitioner has prayed for to furnish the documents what are the inquiry relied upon. That is the annexure to the application I have submitted. Then, my lord, the authority by letter dated 3523, that
Well-
3523 I have not given, but only that letter which 3123. So that letter they have supplied to me. And in that letter, your lordship, by that amount, that whatever amount, the charge number 2 and 3, that page 17, para 3, your lordship will find.
Yes.
Page 3, that regarding so transfer of money from society's fund from bank account as per report. This is the, my lord, I want my report submitted by IC Assistant Registered Cooperative Society Filter and Sri Minar Hussain, Inspector FCS Food and Civil Supplies and Consumer Affairs Filter. So
Where are you reading? Where are you reading? Paragraph?
paragraph 3 of page 17.
Paragraph 3. Yes.
Yes, this is the list of document in annex in the that is stated in the charge sheet, my lord. So
Charge sheet has stated which document?
here the IC assistant the report of
31, 2023.
yes.
31, 2023.
So these two reports are not furnished to me. So I could not file my WS, my lord. Only my prayer is there. I have to allow to file WS and to furnish this document, my lord.
What is the law which requires furnishing of document?
My lord, that is rule 9, my lord. Or I have
Furnishing.
furnish or inspecting. Furnish or inspecting. Any of the two, my lord.
Yes, yes, sir.
Either inspecting. Inspecting also with a rule, my lord.
My lord, you may inspect, but your lordship will see, my lord, this letter has been, my lord, he does not dispute that this letter has been, my lord, made available to him. That is 3123.
Yes.
At page, my lord, 20. 3123. This is the letter issued by the Additional Deputy Commissioner to the Deputy Commissioner. Now, if you
Mr. Doctor,
no, my
page 16 is what?
16. That is type copy, my lord. Same document. I am drawing your lordship's attention to the original one, my lord. This is a type copy, my lord. Your lordship may come to 16 also, no problem.
This is the letter.
Yes, yes. Now, if your lordship comes to page 19.
19.
Yes.
Yes.
Now, along with this particular letter, those reports were, my lord, enclosed. That, sir, para 7, as per report submitted by Minar Hussain, Inspector so-and-so, a statement of the chairman, the incumbent secretary, and FPS agent of Gumrah are enclosed herewith. For
No,
favor of
I
your
did not receive, my lord. I did not.
So, this particular letter accompanies, my lord, this particular report.
No, Mr. Sinha.
I did not receive any
Mr.
such
Sinha,
letter.
Mr. Sinha, see, you were aggrieved by non-granting of the documents.
Yeah,
which
these
has
two
been-
documents, because I have to
No,
reply
see,
it. my lord.
see, which is a letter of 31/2023.
Yes, my lord.
That 31/23 is given to you.
No, that letter is given to me.
Yes.
Now, this letter involves two reports. On that report, the inquiry is based that,
Those reports are not part of the third sheet.
my lord, that parts of charge sheet, my lord.
No.
Yes, my lord. Yes,
No,
yes,
no,
yes. yes.
not
No,
part.
no,
Your
No.
lordship will see para 14, page 14.
no. This
Page 14.
so-called notice only refers to
That
a
letter,
document 31 that has
Yes.
been given to you.
that letter is
No,
given to you.
31 given to you.
You cannot delay the proceedings.
Yes,
No, no,
yes,
no,
yes.
no, no,
Absolutely, but
I
that
am.
is the reason.
I will accommodate with the inquiry, my lord. Just the thing that these two documents are
Allegations are very serious, my lord.
Look, these two documents are directly related to the amount involved in the case. Until and unless I receive this document,
Maybe
my lord, kindly these two
maybe
documents
31
are
is given, though part of enclosure of 31 we are not bothered with this. It cannot be so
No,
stringent
this
to win
amount,
everything.
my lord, this amount they have brought from their two report, my lord. Report of IC ARCS and report of Minar Hussain. This 41 lakhs.
Those two reports are not part of the so-called notice. So-called notice has only referred to a
Yes, letter.
A letter has referred to some report. Report may be part of the proceeding, may not be part of.
My lord,
If it is not part of the, not part of the matter, case goes. If it's part of the procedure, you can raise that is not part of the document.
no, this is
How do you
part of
raise-
proceeding. This is part of proceeding, my lord. Yes, yeah, here the paragraph 3, my lord, the page.
See,
Yes.
a report finds mentioned in a particular letter.
Yes, mention,
The
my lord.
letter is 31/2023, which also mentions two reports.
Yes, my lord.
And this letter is a part of the Stokols note.
Yes,
You say that the report being a part of this letter, the copies of the report should also be given to me. That is your submission, correct?
Yes.
But unless the Stokols notice specifies that this report would also be taken against you, you are not entitled to.
No, your lordship, then list of document, that letter is list of document is there.
Letter you have got.
No, the letter I have got, but the charge, that amount involved,
What
41,
is there in the letter, we
then I may be allowed to file WS, my lord. Then only inquiry process.
Nobody is covering him, my lord.
No,
is the time
no,
over?
no. From tomorrow, inquiry officer will start inquiry, my lord.
WS
Tomorrow is
not-
the day.
WS not filed.
No, because these two documents I did not get. That may be my misunderstanding, but WS may be allowed to file. my lord.
Take it,
Yes, that should go from your lordship, my lord. He will file tomorrow.
not
Not.
tomorrow.
Acting tomorrow can go.
My lord.
At least 1 week.
He
my
is
lord.
aware of the
No,
case,
no,
my
no,
lord.
no. At least 1 week. At least 1 week. At least
But
1
his
week.
WS is ready, you know.
Yes, that is ready.
No, no, no. This document, my
He will
lord,
file
kindly,
tomorrow, my lord.
that may be
Right
accommodated.
now, one phone call.
No, no.
Submit it. Don't
That may be allowed.
plan A, plan B. A is not going to work. B is also not going to work.
My lord.
Lordship will record. He is, my lord, praying for submission of the.
WS within 1 week, my
Lordship
lord.
will grant it.
What is it?
Yes, yes, Lordship will record. it, my
Heard
lord.
previous in a standard counsel for the petitioner. Also heard the SK Talukar, standing counsel, Corporation Department. This writ petition which has been taken up out of turn by way of mentioning pertains to departmental proceedings initiated by a Stokols notice dated 21/3/2023. Full stop. The petitioner, who is
Junior
who is serving as junior inspector, public auditor of cooperative societies in the district of Dhubri,
Dhubri now.
has been served with a Stokols notice dated 21/3/2020. Sri Srinath, the learned counsel for the petitioner, submits that the present petition has been filed with a limited prayer. By drawing the attention of this court to the list of documents, Christina, the learned counsel submits that a letter number C and C dated 30/1/2020 has been mentioned. Full stop. Though it is not disputed that copy of the letter
Yes, that's fine.
has been furnished to him, the state letter, on the other hand, takes into account two reports, copies of which have not given the petition. It is submitted that without such copies of the report, the petitioner would be deprived from submitting an effective statement of defense. It is accordingly submitted that adequate direct grant be issued for furnished copies of the report so as to enable the petitioner to submit an effective defense case. Christina further informs this court that tomorrow is the day scheduled for the inquiry.
Yeah.
On the other hand, from Sri Taludar, the sending on to the department, has submitted that there is no further action in this case at this stage. Full stop. He submits that there is no allegation of violation of procedure, and the letter and the letter is a part of the document. No, and the letter dated 31/2023, which is the only document under the column list of documents in the show cause notice dated 21/3/2023, has admittedly been furnished to the petition. Full stop. He submits that unless any other documents are made part of the list of documents, the petitioner, the delinquent is not entitled to seek copies of the same as a matter of right. And then after considering the rival submission, this court is of the opinion that since the letter dated 31/2023, which is the only document mentioned has already been furnished to the petitioner, there is no other requirement to give copies of reports which finds mention in the state letter. If any other documents are taken into consideration in the inquiry, the petitioner would have his own remedies at that stage. This court is accordingly of the view that no case for interference is made out at this stage, and according to the writ is dismissed. At this stage, Sri Sinha submits that he may be permitted to submit the statement of defense and to facilitate the same, the inquiry scheduled tomorrow may be deferred by a reasonable period. The aforesaid submission is not opposed in principle by State Allocator, who, however, contends that a fixed date be given so that the inquiry may be held expeditious. In view of the above, the inquiry scheduled tomorrow may be deferred by a week, by which time the petitioner may file the written statement of defense from every side. To clarify matter, the statement of defense may be filed within by which date?
By 14th, my lord. 7 days will complete.
7 days within a week.
By 14th of
September.
4 days, 7. Yes, madam. Just one, my lord, that in place of dismissal, it may be closed, my lord, because it may have different implications also. Close, it may be closed, my closed, my.
Disposed of.
Yeah, disposed.
My lord, in case of non-filing, inquiry will proceed.
Yes, I will find.
Who is that may?
Yes. Oblige, my lord. I will.
Lordship, I'm on a prayer for adjournment. As my senior is unable to appear, let it be come on next.
Who is the senior, madam?
J. Pine.
Where is he gone? He was there in the morning.
Lordship, he has some difficulties.
Okay, 22, madam. You're lucky, madam. Madam. A prayer for adjournment has been made on behalf of the J. Pine, current counsel for the petition. Also, our professor, Senate, pending counsel. Yes, PWD.
So, my lord, I have got a finance.
Finance department. As we heard her and it now. Sarah, this after when? 1 week.
On Thursday, next Thursday, 14. 1 week.
What is the matter, madam?
It's a
Petitioner is seeking my lord back wages with regard to my lord his past
This
service.
after a week.
Already DP has been concluded. Everything has been settled by this.
1 week. One. Return matters not. 22 matters. Yes, next.
next one.
Yes.
May I please, your lordship? My lord, this matter, lord, relates to selection and appointment of the Gram Pradhan, my lord. Gaon Buras, my lord, nowadays has been termed as Gram Pradhan, my lord. My lord, what has happened, my lord? I am underage at this moment, my lord. In response to the time-to-time notification which they have amended the age, my lord.
Revenue, Mr. Dotto, you
My lord. They have filed an affidavit, my lord. I have received a copy, my lord. I have gone through. A little time is required for filing the rejoinder.
Who is filed?
My lord, the revenue has filed, my lord. My friend has filed, my lord. It's filed on 13/6, my lord.
There is no interim order.
My lord, initially there was an interim order, my lord.
Secondly.
Later on, it was modified.
Now who's holding this charge?
Now, my lord, because of this case, my lord, although I am selected, I have not been appointed.
No, there is no any
Therefore,
embargo.
my lord, we
There
have
is no interim order.
lordship.
My lord, already it has
Will
been.
not advise you what to do. You know what to do.
My lord. He can come up with a petition, my lord. No petition, no affidavit till date, my lord. We have also questioned, my lord, the legality and validity of his selection because he is an outsider
You have
of
not
this.
filed affidavit.
My lord.
No, my lord.
No,
Right.
My lord. the
He's an
government-
outsider.
he's an outsider. We have specifically pleaded, my lord. No,
He is not eligible to file application. He is underage.
That's
So he
why-
cannot challenge the selection
No, my
process.
lord, we have challenged the notification by which we have been make underage, my lord, as well as the selection of the response. I am the in charge, Gram Pradhan
The ground of underaging is also
under challenge, my lord. My lord. And my lord may decide, my lord, whether my,
what does the rules, what do the rules?
my lord, what is, yes, my lord, the rule says that it should be at present 30 years for the minimum age, my lord, and I am 22 years at this moment, my lord, but initially it was 21 years, my lord. Then, my lord, that notification has been amended time to time as per
But
the,
the nomenclature changed different matter.
that's
It was
correct,
Gaonpura, it was not Gaon Deka.
my lord, that,
22, it cannot be Gaonpura.
my lord, not 30 is also a, my lord,
30
no,
is also not Pura.
my lord, my lord.
Till then,
My
it
lord. What, my lord, it's the age. That's why, my lord, we have said that the initially while it was 21, there is no rationality has been there, my lord. Time to time, my lord, they had for no reason, and there is already a direction, my lord, from this honorable court that the government should take a decision.
cut off without any malafide intention,
My
can
lord.
you interfere?
That is the, my lord, whims, my lord, within the, my lord,
Cut
limit
off
of the
without
government.
any malafide intention, can you interfere?
No, my lord, malafide, we cannot say,
Is
my
it,
lord.
is the cutoff in, inserted only to deprive you?
My lord, different year, different notification, different date, cut-off date, my lord. Even my learned friend has also challenged one petition, my lord, when it was 35. Now they have come down to 30. So, my lord, we are pressing this petition, my lord, if we can
Maybe
succeed.
next year it will be 25.
It was
My lord.
35, it was enhanced to 35,
30.
again reduced to 30.
30, my lord,
Now, my lord, 30 is holding the field.
for holding the field, my lord. My lord, admittedly, my lord, to be submitted fairly. At the age, my lord, if this notification survive, then I do not have any case, my lord. But at present, my lord, I am holding the charge of the very lot, my lord, wherein this selection process is going on since last 2 years, my lord, from the date of retirement.
That time it was permissible.
No, my lord, that time also the age limit does not permit me, but government allows me to hold the charge and I am functioning, my lord, to the satisfaction of the
You are
authority,
so influential, why have you come to the court?
my lord.
You are so influential, why
No,
have
my
you
lord,
come
no,
to
it
the
is,
court?
yeah, no, my lord, it is not under my influence, my lord.
25% allowed to hold charge for 2 years.
No, no, my lord, it is with all,
Long
with,
hands.
my lord, with all respect, what I am respectfully submitting before my lord, my lord, is that it is not a case of influence, my lord. They have voluntarily in a
Why you? Why you?
my lord, because I was the my lord, son of the late Gaunpura, my lord. And there is a provision has also been made, my lord, that the preferences shall be given to the my lord.
Even if you do not meet the age criteria.
No, my lord, that is not the issue, my lord. They have said, my lord, in the guideline that the preference shall be given. My lord, may
You have
hear it,
already got benefit.
my lord.
Okay, well, how much time?
My lord, 10 days time is sufficient, my lord.
You would like to file a affidavit?
My lord, we will file evidence, my lord, one clarification, my lord, pendency shall not be bar, my lord, that was the reason.
That is my
No, no,
petition, my lord.
because
That is
otherwise-
already clarified, my lord.
Will not send it.
My lord.
Because,
You
my lord,
file an application. Not here, you file an application to them, there is no stay order.
My
You know what to do, annex this petition, annex this last order copy.
I am my lord, written
Ah.
on the-
We are here, we are
Right.
that the Department of Revenue
Right.
has filed an affidavit to which he would like to file a rejoinder.
Right.
We are the Senate Council respond number
Four, my lord.
4 may also file. And then also please for time to file the affidavit. Put the para list of 10 days. By
Right.
which time affidavit may be exchanged.